La question est la suivante.
The question is as follows. Mr. Van Loan, seconded by Mr. Nicholson, moved that in relation to Bill C54, an act to amend the Criminal Code and the National Defense Act, mental disorder, not more than 5 further hours shall be allotted to the consideration of the second reading stage of the bill.
To the 5 hours on the consideration of the second reading stage of the said bill. Any proceedings before the House shall be interrupted, if required for the purpose of this order, and in turn, every question necessary for the disposal of the said stage of the bill shall be put forthwith and successively without further debate or amendment. All those in favor of the motion will please rise.
Mr. Harper. Mr. Fletcher. Mr. Fantino. Mr. Ashfield. Mr. Lebel. Ms. Ambrose. Mr. Taves. Mr. Nicholson. Mr. McKay Central Nova. Mr. Van Loan. Mr. Paradis. Mr. Clement. Mr. Ritz. Mr. Kenny Calgary Southeast. Mr. Moore Port Moody Westwood Port Coquitlam. Mrs. Zaglukak. Mrs. Shea. Mr. Fast. Mr. Blaney. Mr. Oliver. Ms. Raitt. Ms. Finley Delta Richmond East. Mr. Duncan Vancouver Island North. Mr. Benoit. Mr. Brightkreitz. Mr. Merrifield. Mr. Moore Fundy Royal. Mr. Camp Pitt Meadows Maple Ridge Mission. Mr. Poiliev. Mr. Lake. Mr. O'Brien. Mr. Dykstra. Mr. Bernier. Mr. Gossard. Mr. Goodyear. Mr. O'Connor. Mrs. Yelich. Mrs. Wong. Mrs. Oblonsky. Mr. Upal. Mr. Calandra. Mr. Gould. Mr. Carey. Mr. Anders. Mr. Reid. Mrs. Gallant. Mr. Lunny. Mr. Rajat. Mr. Sorensen. Mr. Allison. Mr. Bazan. Mr. Brown Leeds Grenville. Mr. Hahn. Mr. Chong. Mrs. Greywall. Mr. Alexander. Ms. Rempel. Mr. Gauguin. Mr. Rickford. Mr. Delmastro. Mr. Lemieux. Mr. Lukiski. Mrs. Troupe. Ms. Adams. Mrs. Glover. Mr. Leong. Mr. Saxton. Mr. Deckert. Ms. Brown, Newmarket Aurora. Mrs. McLeod. Mr. Hebert. Mr. Jean. Mr. Komarnicki. Mr. Cram Prince Edward Hastings. Mr. Lauzon. Mr. Mackenzie. Mr. Miller. Mr. Preston. Mrs. Smith. Mr. Tilson. Mr. Trost. Mr. Tweed. Mr. Warwa. Mr. Watson. Mr. Allen Tobic McTaquac. Mr. Brownberry. Mr. Bernouge. Mr. Calkins. Mr. Cannon. Mr. Albrecht. Mrs. Davidson. Mr. Galipo. Mr. Mays. Mr. Norlock. Mr. Shipley. Mr. Storseth. Mr. Sweet. Mr. Van Kestren. Mr. Wallace. Mr. Workington. Mr. Clark. Mrs. Block. Mr. Bowen. Mr. Braid. Mr. Dreeshen. Mr. Hoback. Mr. Holder. Mr. Kerr. Mr. Lobb. Mr. Rathgaber. Mrs. O'Neill Gordon. Mr. Payne. Mr. Richards. Mr. Shorey. Mr. Weston, West Vancouver, Sunshine Coast, Sea to Sky Country.
Mr.
Weston, St. John. Mr. Woodworth. Mr. Young Oakville. Mr. Armstrong. Mr. Sopuck. Mr. Harris, Caribou, Prince George. Mr. Adler. Mr. Albus. Mrs. Ambler. Mr. Aspen. Mr. Butt. Mr. Carmichael. Mr. Chizu. Mr. Daniel. Mr. Hayes. Ms. James. Mr. Menegakis. Mr. Tote. Mr. Wilkes. Mr. McColeman. Ms. Young, Vancouver South. Mr. Leeson. Mr. Opitz. Mr. Seaback. Mr. Straw. Mr. Trottier. Mr. Williamson. Mr. O'Toole. Ms. Crockett. Mr. Zimmer. Mr. Stanton. Mr. Devolan.
All those opposed to the motion will please rise.
Monsieur Mulcair. Madame Day. Mr. Alan Wellen. Ms. Chow. Mr. Dewar. Mr. Harris St. John's East. Madame Boivin. Ms. Leslie. Mr. Cullen. Mr. Christopherson. Ms. Nash. Mr. Julian. Ms. Crowder. Mr. Davies, Vancouver Kingsway. Ms. Matheson. Ms. Duncan, Edmonton Strathcona. Madame Perrault. Mr. Martin. Madame Ayala. Madame Ayala. Madame Moore, Abitibi-Témiscamingue. Madame Moore, Abitibi-Témiscamingue. Mr. Massey. Mr. Massey. Mr. Donnelly. Mr. Donnelly. Ms. Sims, Newton North Delta. Ms. Sims, Newton North Delta. Mr. Kelway. Mr. Kelway. Madame Brosseau. Madame Brosseau. Madame Groguet. Madame Groguet. Madame Turmel. Madame Turmel. Ms. Charlton. Ms. Charlton. Mr. Chisholm. Mr. Chisholm. Monsieur Boudris. Mr. Boudris. Mr. Angus. Mr. Angus. Mr. Marston. Mr. Marston. Madame Hughes. Madame Hughes. Monsieur Dubé. Monsieur Dubé. Madame Laverdière. Madame Laverdière. Mr. Scott. Mr. Scott. Madame Papillon. Madame Papillon. Monsieur Dussault. Monsieur Dussault. Mr. Cash. Mr. Cash. Mr. Stewart. Mr. Stewart. Mr. Garrison. Mr. Garrison. Madame Blanchette-Lamotte. Madame Blanchette-Lamotte. Monsieur Aubin. Monsieur Aubin. Mr. Harris Scarborough Southwest. Mr. Harris Scarborough Southwest. Monsieur Toon. Monsieur Toon. Madame Boutin-Sweet. Madame Boutin-Sweet. Monsieur Saganache. Monsieur Saganache. Monsieur Caron. Monsieur Caron. Madame Piclet. Madame Piclet. Monsieur Gravel. Monsieur Gravel. Monsieur Maille. Monsieur Maille. Monsieur Larose. Monsieur Larose. Monsieur Giguère. Monsieur Giguère. Monsieur Côté. Monsieur Côté. Monsieur Genet-Jourdain. Monsieur Genet-Jourdain. Monsieur Lapointe. Monsieur Lapointe. Monsieur Choquette. Monsieur Choquette. Madame Lou. Madame Lou. Mr. Sandou. Mr. Sandou. Madame Sella. Madame Sella. Madame Quash. Madame Quash. Mr. Rankin. Mr. Rankin. Monsieur Nantel. Monsieur Nantel. Madame Latendresse. Madame Latendresse. Madame Freeman. Madame Freeman. Monsieur Blanchette. Monsieur Blanchette. Madame Michaud. Madame Michaud. Mr. Adamanenko. Mr. Adamanenko. Monsieur Nunez-Melo. Monsieur Nunez-Melo. Monsieur Tremblay. Monsieur Tremblay. Monsieur Chiquan. Monsieur Chiquan. Monsieur Dion Labelle. Monsieur Dion Labelle. Mr. Cleary. Mr. Cleary. Monsieur Morin-Chicoutimi-Lefiard. Monsieur Morin, Chicoutimi-Lefiard. Madame Doré-Lefebvre. Madame Doré-Lefebvre. Madame Morin, Notre-Dame de Grâce-la-Chine. Madame Morin, Notre-Dame de Grâce-la-Chine. Madame Reynaud. Madame Reynaud. Monsieur Genet. Monsieur Genet. Monsieur Nichols. Monsieur Nichols. Monsieur Morin, Laurentier-de-la-Belle. Monsieur Morin, Laurentier-de-la-Belle. Monsieur Trudeau. Monsieur Trudeau. Mr. Ray. Mr. Ray. Mr. Goodale. Mr. Goodale. Monsieur Leblanc-Beauséjour. Monsieur Leblanc-Beauséjour. Mr. Macaulay. Mr. Macaulay. Mr. Easter. Mr. Easter. Ms. Fry. Ms. Fry. Mr. Regan. Mr. Regan. Monsieur Bélanger. Mr. Bélanger. Ms. Foote. Ms. Foote. Mr. Lamoureux. Mr. Lamoureux. Ms. Bennett. Ms. Bennett. Mr. Bryson. Mr. Bryson. Ms. Scrow. Ms. Scrow. Mr. Cuzner. Mr. Cuzner. Mr. Iking. Mr. Iking. Mr. McCallum. Mr. McCallum. Mr. Garneau. Mr. Garneau. Mr. Casey. Mr. Casey. Mr. Sims, Bonavista, Gander, Grand Falls, Windsor. Mr. Sims, Bonavista, Gander, Grand Falls, Windsor. Ms. Murray. Ms. Murray. Mr. Andrews. Mr. Andrews. Ms. Duncan, Etobicoke North. Duncan, Etobicoke North. Mr. Valeriot. Mr. Valeriot. Mr. Chou. Mr. Chou. Monsieur Plamondon. Monsieur Plamondon. Monsieur Fortin. Monsieur Fortin. Monsieur Patry. Monsieur Patry. Mr. Heyer. Mr. Heyer. Ms. May. Ms. May. Yeas pour 147, 147, nays contre 110, 110.
I declare the motion carried. Orders of the day, order du jour.
Orders of the day, government orders, government bills, comments, resuming debate at second reading of Bill C54, Not Criminally Responsible Reform Act.
I just thought we'd give a minute to...
We're on C54. Yes, if you don't mind address, that'd be great. I do. A little bit of lemon. Order. I'd ask all honourable members who wish to carry on discussions to make their way out of the chamber. We're on debates. The Honourable Parliamentary Secretary to the Minister of Justice.
Participate in the second reading debate on Bill C54, the Not Criminally Responsible Reform Act. This is a legal policy issue that has preoccupied many Canadians, not only today, but over the years. Recent high-profile cases in many parts of Canada have caused Canadians to question whether our laws in this area are strong enough or clear enough to ensure that the public is adequately protected when risk to public safety exists. In my remarks, I plan to outline the key milestones in Parliament's consideration of this issue. I think it is important to canvass the legislative history of the criminal code mental disorder regime in order to put today's debate in context, essentially to have a clear understanding of how Bill C54 seeks to build on and improve the existing law. Mr. Speaker, what used to be referred to as the insanity defense was included in Canada's first criminal code, which was enacted in 1892. And even before then, the defense existed at common law. It stemmed from a decision rendered in 1843 from the British House of Lords. The common law principle was known as the MacNaughton Rules, was stated as follows. Every man is presumed to be sane and possess a sufficient degree of reason to be responsible for his crimes until the contrary be proved to their jurors' satisfaction. And that to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the party accused was laboring under such defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or not to know that what he was doing was wrong. The text of the first criminal code stated, no person shall be convicted of an offense by reason of act done or omitted by him when laboring under natural imbecility or disease of the mind to such an extent as to render him incapable of appreciating the nature and quality of the act or omission and of knowing that such act or omission was wrong. This legislation continued to apply relatively unchanged and without much public debate for the first half of the 20th century. In 1977, the Law Reform Commission of Canada produced a report to Parliament on mental disorders in criminal process, which made 44 recommendations about procedures and dispositions for the mentally disorder offender. In order to consider and in response to the recommendations, the Department of Justice launched the Mental Disorder Project in 1978. The review process led to the release of a discussion paper in 1983 exploring over 100 issues in the area of psychiatric remands, fitness to stand trial, the defense of insanity, and criminal responsibility, just to name a few. A final report was produced in 1985, followed shortly thereafter by a draft bill that was introduced in the House of Commons by the Minister of Justice, then John Crosbie. Mr. Speaker, the proposed amendments to the criminal code in the draft bill were the first formulation of what would eventually become the new criminal code mental disorder regime. The proposed amendments sought to modernize and clarify the criminal law on mental disorder to strengthen due process and to ensure the continued protection of the public. It proposed to change the law in a number of respects. Under the law at the time, insane or unfit accused were held in strict custody under the pleasure of the Lieutenant Governor of the province was known. There wasn't a requirement to hold a hearing, and the Lieutenant Governor's decisions, essentially the provincial cabinets, were not subject to appeal. There were, therefore, many gaps with respect to due process that needed to be remedied. In 1986, the draft bill proposed to remove the role of the Lieutenant Governor in the process and to establish review boards in all jurisdictions with uniform procedures to follow across the country. Another significant change in the draft bill was to replace the defense insanity with the verdict of not criminally responsible on account of mental disorder. I'll have more to say about that amendment in a moment. Discussions and consultations with the provinces and territories on the draft bill and other intervening events resulted in the bill not being introduced until 1991 as Bill C-30. It was proposed much of what was contained in the 1986 draft bill. With respect to the previous defense of not guilty by reasons of insanity, I think it is noteworthy to highlight that the Minister of Justice's remarks, then Kim Campbell, about that amendment. She said that a number of psychiatrists had indicated that persons found not criminally reasoned by reason of insanity deluded themselves into thinking that they have done nothing wrong, and this presents an obstacle to therapy. She also explained that the previous wording was difficult for the public to understand, how the accused could be found not guilty despite proof that he committed the offense. The not guilty by reason of insanity defense was therefore replaced with the verdict of not criminally responsible on account of mental disorder. However, I think it fair to say, Mr. Speaker, that the public still has difficulty understanding the not criminally responsible verdict. I believe that it is part of our job as parliamentarians to talk about the verdict and to help explain it to the public. Therefore, I would like to reiterate that the verdict of not criminally responsible on account of mental disorder is not an acquittal, nor is it a conviction. It is a special verdict that the court makes when it has been established that a person committed an act or made an omission that constitutes a criminal offense. What is also to be established as a legal issue for the court to determine is whether the person suffered from a mental disorder at the time of the commission of the act or omission that rendered the person incapable of appreciating what they did or knowing that it was wrong. When the court enters a verdict of not criminally responsible on account of mental disorder, it does not release the accused. The accused is referred to a provincial or territorial review board that is responsible for making orders to govern how the accused will be dealt with. Bill C-30 introduced 3 possible orders that can be put into place depending on the level of risk posed by the person. Only if the person does not pose a significant threat to the public safety will the person be discharged without conditions. If the person poses a significant threat to the safety of the public, the person will be kept in custody in a hospital or discharged with conditions. The choice between custody or a conditional discharge is determined in accordance with the level of risk posed to the public safety. Bill C-30 also introduced the factors that must be taken into consideration in deciding which order should be put in place. The section provides that the court or review board shall take into consideration the need to protect the public from dangerous persons, the mental condition of the accused, the reintegration of the accused into society, and the other needs of the accused. Mr. Speaker, this is a key provision of the Criminal Code mental disorder regime as it guides the courts and review boards in their decision-making. It was introduced in 1991 by Bill C-30 to provide criteria and factors that did not previously exist in the legislation. As I mentioned in the beginning of my remarks, I want to take some time to canvass the legislative history of the Criminal Code mental disorder regime in order to put Bill C-54 in context and to better understand how it seeks to build on and improve the existing law. With respect to this key decision-making process, Bill C-54 proposes to clarify that among the existing listed factors that the courts and review boards must consider when they make decisions with respect to the mentally disordered accused, public safety is the paramount consideration. It goes on at Clause 9 where it says, when a court or review board makes a disposition, it shall, taking into account the safety of the public, which is the paramount consideration, the mental condition of the accused, the reintegration of the accused into society, and the other needs of the accused, make the disposition that is necessary and appropriate in the circumstances. Bill C-54 also clarifies what is meant by the phrase significant threat to the safety of the public. In 1999, the case of Wingo versus British Columbia Forensic Psychiatrist Institute, the Supreme Court of Canada interpreted that phrase to mean a risk of serious physical or psychological harm to members of the public resulting from conduct that is criminal in nature but not necessarily violent. Bill C-54 codifies the Supreme Court's interpretation. Mr. Speaker, the mental disorder regime that was introduced in 1992 included new rules and procedures with respect to appeals. I mentioned earlier that the previous law did not provide either party with a right of appeal of a lieutenant governor's decision. Last year, the Court of Appeal for Ontario identified a problem with one of the appeal provisions in this part of the code. The Criminal Code currently states that when an absolute discharge is appealed, the absolute discharge is automatically suspended. In Ree versus Kobzar, the Court of Appeal for Ontario found this automatic suspension to be in violation of Sections 7 and 9 of the Charter, but suspended its order to allow Parliament to pass an amendment to correct the defect. The proposed reforms would eliminate the automatic suspension of the absolute discharge and instead would grant the Court of Appeal the discretionary power to suspend the absolute discharge if the mental condition of the accused justifies it. Mr. Speaker, I support the effort to clarify this area of the criminal law. The reform seeks to improve the existing legislative framework that guides decision-making when courts and review boards hear matters involving mentally disordered accused persons. Bill C-54 would help ensure more consistent interpretation and application of the law across the country. That is a valuable goal. In my view, the proposed reforms are reasonable measures to take into consideration the protection of the public and to ensure confidence in our justice system. Mentally disordered accused will continue to receive treatment and have their cases overseen by the courts and the review boards. I encourage all members to support passage at second reading of Bill C-54. This would mean that it would be referred to committee for further study. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire?
The Honourable Member for Hochelaga. Thank you, Mr. Speaker. I was wondering if the emphasis is put on victims in this bill, does the government intend to offer new programs to help victims even more?
The Honourable Parliamentary Secretary to the Minister of Justice.
I thank the Honourable Member for her question. As she knows, there is a whole range of services already offered by the government, and when we study this issue at committee, there's every chance that there will be testimony that will lead us to any shortcomings in the services that we offer now. We know that victims of crime are always a concern to us. Thank you.
The Honourable Member for Okanagan-Coquihalla.
Thank you, Mr. Speaker, and I'd certainly like to thank the Parliamentary Secretary to the Minister of Justice for his speech in regards to this much-needed legislation. In fact, this is something that is of concern in my riding of Okanagan-Coquihalla, particularly during the last election when I door-knocked. There was a tragic case of 3 children being murdered by their father in the city of Merritt, and this still is a very difficult issue for my riding. Mr. Speaker, certainly the Parliamentary Secretary has done a lot of work in supporting victims' rights, particularly the victim surcharge. We've doubled that. Many opposition members chose to vote against that important legislation. But what I'd like to ask the Parliamentary Secretary, not about so much about victims' right at this time, we want to empower victims so they have more information, but we also want to empower the judiciary to be able to put forward high-risk designations. And that allows for a check that many victims have raised as being that there's a gap in the system. I'd like to hear the Parliamentary Secretary's comments in empowering the courts and also helping victims to be protected through this legislation. Thank you.
Secretary Parlementaire du Ministre.
The Parliamentary Secretary to the Minister of Justice.
Certainly the tragedy which occurred in his riding is an illustration of why this law has been brought forth, to make the protection of the public the paramount consideration when it comes to the release of mentally affected offenders. And certainly not all mentally affected offenders will be higher risk designation, but the court will always look at this question, and in the event where an offender is in fact a high risk offender, much more security will be placed around this person. They will not be able to go in unescorted visits. Their escorted visits will be for health conditions, and certainly victims will always be, upon their release when that occurs, and if that occurs, be made informed of when they will be released, and there would be enough information so that they could avoid encounters with people who they would be absolutely terrified of. This is all about one single thing: protecting the public and balancing the protection of the public with the rehabilitation of the offenders, and making less of a disruption to the victims, who basically are people who have been sentenced for the rest of their lives through circumstances beyond their control.
Questions and comments. The Honourable Member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I've seen many bills go through this House where the financial obligation is passed on to the provinces or the cities or the First Nations. I want to ask the Parliamentary Secretary if he can assure this House whether any financial discussions have taken place with the provinces so they're not left holding the bag. Who is responsible for carrying out the responsibilities for this bill, and whether any federal transfers will be done to the provinces?
Good question. Parliamentary Secretary to the Minister of Justice.
That's a very interesting question, Mr. Speaker. In fact, this bill has been brought forth at the request of the provinces and territories because they have a concern for the safety of the public. And as to the cost, I mean, transfers to the province are at an all-time high. I believe it was $64 billion last year. And there's a cost to protecting the public. And certainly in this case, the provinces and the territory have sought to get the additional protection. And it's within, of course, their purview to want to protect their public, as do we.
Questions and comments. Questions and commentaires. Resuming debate, the Honourable Member for St. John's South Mount Pearl.
Thank you, Mr. Speaker. I'll be splitting my time with the member for Portneuf, Jacques Cartier. I stand in support of Bill C54, an act to amend the Criminal Code and the National Defence Act in relation to mental disorder, Mr. Speaker. The bill's short title is the Not Criminally Responsible Reform Act. To be more specific, New Democrats support the bill so that it can be further studied in committee. It merits further study, Mr. Speaker. Cutting to the chase, this bill amends the legislative framework applicable to mental disorder in the Criminal Code and the National Defense Act. It amends the legislation to specify that the safety of the public is the paramount consideration in the decision-making process. I repeat, because this is key, Mr. Speaker, public safety must be paramount in the decision-making process. The bill also creates a mechanism by which Canadians who are found not criminally responsible on account of mental disorder may be declared high risk. And the bill increases the involvement of victims. I'll have more to say about that in just a moment, Mr. Speaker. First, an overview of the current Criminal Code mental disorder regime. The current Criminal Code mental order regime applies to a small percentage of accused. Under Canadian criminal law, if an accused person cannot understand the nature of the trial or the consequences and cannot communicate with their lawyer on account of a mental disorder, the court will find that the person is unfit to stand trial. Then, once that person becomes fit to stand trial, they're tried for the offense with which they were initially charged. At the same time, Mr. Speaker, if a person is found to have committed an offense but lacked the capacity to appreciate what they did or know that it was wrong due to a mental disorder at the time, the court makes a special verdict of not criminally responsible on account of mental disorder. They're either convicted or they're acquitted, Mr. Speaker. A person found either unfit to stand trial or not criminally responsible is referred to a provincial or territorial review board, and the board, Mr. Speaker, decides on the course of action. Under the current law, a review board can make one of three possible decisions. First, if the person doesn't pose a significant threat to public safety, an absolute discharge. Now, that's only available to a person found not criminally responsible. Second, number two, a conditional discharge. And the third option, Mr. Speaker, that's open to a review board is detention in custody or detention in a hospital. This bill proposes to amend the mental disorder regime in three ways, Mr. Speaker. First, putting public safety first. And I can't stress that enough, Mr. Speaker. Putting public safety first. Public safety must come first. The changes proposed in this bill would explicitly make public safety the paramount consideration in the court and the review board decision-making process. Second, Mr. Speaker, the legislation would amend the criminal code to create a process for the designation of those found not criminally responsible as high risk. That's the designation, high risk. That's in the case where the accused person has been found not criminally responsible of a serious personal injury offense, where there is a high likelihood, Mr. Speaker, for further violence that would endanger the public, or in cases where the acts were of such a brutal nature as to constitute a risk of grave harm to the public, Mr. Speaker. As for what happens when a not criminally responsible person is designated high risk, Mr. Speaker, well, they would not be granted a conditional or absolute discharge. That would not happen, Mr. Speaker. Further, the designation of high risk would only be revoked by the court following a recommendation of the review board. Now, this bill outlines that a high-risk, not criminally responsible person would not be allowed to go into the community unescorted. Again, it's all about public safety, Mr. Speaker. And the escorted passes would only be allowed in narrow circumstances and subject to sufficient conditions to protect public safety. Also, Mr. Speaker, the review board may decide to extend the review period for those designated high risk to up to 3 years instead of annually. The third way, Mr. Speaker, that this bill proposes to amend the mental disorder regime is by enhancing the safety of the victims and provide them with opportunities for greater involvement in the criminal code mental disorder regime by 3 ways, Mr. Speaker. First, ensuring they're notified upon request when the accused is discharged. Second, allow non-communication orders between the accused and the victim. And third, Mr. Speaker, ensuring that the safety of victims is considered when decisions are being made about an accused person. Provisions in the proposed legislation would help ensure consistent interpretation and application of the law across the country. Across the country, Mr. Speaker. Amending the legislative framework applicable to mental disorder in the Criminal Code and National Defence Act is a difficult issue for victims, it's a difficult issue for families and for communities. But I can't repeat this enough, Mr. Speaker. The public safety must come first when complying with the rule of law and the Canadian Charter of Rights and Freedoms. Again, Mr. Speaker, we support this bill so that it can be further studied in committee. In the coming weeks, during the committee stage, we'll talk to mental health experts, victims, and the provinces to find out what they believe is the best approach. But, and this is a big but, Mr. Speaker, we don't want to play political games with this bill. We must focus on the policy's merits. As for consultation / who pays the cost, and that was a question that was asked of the Conservative speaker who spoke last. In a Global News interview, a spokesperson for the Justice Department stated that the provinces, Mr. Speaker, would be responsible for assuming the costs of the new policy. That said, Mr. Speaker, we must ensure that the provinces have the financial resources to pay for the new policy. But, Mr. Speaker, there are other unknowns. There are other unknowns right now. There are outstanding questions, information that the federal Conservatives should be able to provide. Again, Mr. Speaker, with this bill, public safety must be paramount. But we also need the information, the data, to make the best decisions that we can make. One outstanding question, the first of several. I have several questions, Mr. Speaker. What statistics did the government collect on persons deemed not criminally responsible on account of mental disorder? And those stats we'd be looking for by province, by territory, and by type of offense. Another question, Mr. Speaker. How many people were deemed not criminally responsible altogether, say, over the past 10 years, and how many of those people were granted an unconditional discharge? Another question, Mr. Speaker. Which persons deemed not criminally responsible and discharged were found guilty of a subsequent offense? That's a good question, Mr. Speaker. And another question. What persons deemed not criminally responsible and discharged were deemed not criminally responsible for a subsequent offense? What was the nature of the subsequent offense? Another question, Mr. Speaker. For each of the last 10 years, what was the rate of repeat offenses for all offenders under federal jurisdiction, by province and by territory? Another question, last question I have for right now, Mr. Speaker. Which treatment facilities across the country accept people deemed not criminally responsible, public and private, and how much money is out there to actually look after these people once they're in an institution, if they go to an institution? Now, most Canadians are familiar with Sheldon Kennedy, Mr. Speaker. He's a former National Hockey League player. He's also an abuse victim. His story is well known across the country. Here's what Kennedy had to say when he heard about this bill, and I quote, "What I really like is the focus on victims. I think that's key. And when we look at this type of crime, we catch some child sex perpetrators, but I think it's paramount we take care of the victims of these perpetrators." Mr. Speaker, let me be clear. We want to know how we can help victims. We want to know how we can help victims. Over the next few weeks, we'll talk to mental health experts, we'll speak to victims, we'll speak to the provinces to learn what they believe is the best approach. And I can't stress this enough either, Mr. Speaker. Again, we don't want to play political games with this. We want to examine the merits of the bill, and which must be adequately funded by the federal government. And we need answers to those outstanding questions. What I listed were just several questions. There are many more. And we need the answers to those questions to make the best decisions about moving forward. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Halifax.
Thank you, Mr. Speaker, and I thank my colleague for his speech. And he points out rightly that he has lots of questions. I have lots of questions as well. I spoke to this bill earlier, and I still have questions. one reason we're not able to answer these questions, in my opinion, is we don't know who government has consulted on this. So I want to ask my colleague if he has organizations or individuals, experts in his community that the government has consulted, that he knows about. In Halifax, we have, at the law school, there's a professor who teaches disability law, Archie Kaiser. We have the Atlantic Centers for a number of organizations, like the sort of Atlantic regional offices for, for example, Canadian Mental Health Association or a Schizophrenia Association. As far as I know, none of these organizations have been consulted. And so we want to make sure that public policy is based on the best evidence that's out there, not just on our gut reaction to a couple of high-profile cases. And I wonder if he has heard of any consultation happening in his community about this bill.
Member for St. John's South Mount Pearl.
Thank you, Mr. Speaker. And I thank the honourable member for the question. A very good question. The short answer is, I don't know. I don't know who's been consulted. I know that in my riding of St. John's South Mount Pearl, there's a lot of talk, especially amongst the police authorities about mental health and the fact that the services aren't there for people who suffer from mental health illness. And I mentioned in my speech a number of questions, but the list of questions is as long as my arm. Another question, if I have an opportunity here just for a moment. Some other questions we have that are outstanding. Which treatment facilities, for example, people who, in terms of mental health, which treatment facilities accept people with the mental health illnesses that we outlined, and of the facilities, which are private, how many can each facility, how many people can each facility accept, how many people are currently in each facility, what analysis has the government done to determine if these legislative measures will require these facilities to increase their capacities? There are so many questions, Mr. Speaker, we just don't have answers to.
Questions and comments. The honourable member for Burnaby New Westminster.
Speaker, I'd like to thank the member for St. John's South Mount Pearl for yet another speech in the House that brought, I think, a lot more sense of what is missing from this particular legislation. The member for St. John's South Mount Pearl is one of the most eloquent members in the House of Commons, very hardworking. He does a terrific job. And he raised significant questions, Mr. Speaker, that the government does not seem to have any answers to. Now, we all support the principle of the legislation. We support the principle of helping victims. But the fact that the government is incapable of answering these key questions is very important, Mr. Speaker. So I'd like to ask the member for St. John's South Mount Pearl. The government has a history now of unfortunately, there's no other way of putting it, Mr. Speaker, screwing up legislation. You think of the refugee legislation, the Veterans Charter. In each case, they tried to rush through legislation that hadn't received its due diligence. So I'm wondering if the member from St. John's South Mount Pearl is concerned about the closure motion this government's brought forward. Are they repeating the same mistakes that they have in the past?
Honourable member for St. John's South Mount Pearl.
Thank you very much, Mr. Speaker, and I thank the honourable member for the question. I'm very concerned about closure, and I'm always concerned about any time the government limits debate. That's always a concern. To me, that interferes with our democracy, the way this place is supposed to run. The bottom line here is that our party supports this bill going to committee. And in committee, we're going to bring in experts. We're going to have further study. But with all these questions that are outstanding, we're going to need answers. So this government better be prepared when we go to committee stage to answer some important questions. We don't know if the homework has been done on this bill. In terms of treatment facilities, in terms of raw numbers, on how often people with Canadians with mental health issues, in terms of how often, if they're charged with a crime, if they're convicted of a crime, how often they repeat. They repeat crimes, how often they're put back in jail, whether or not they get the treatment they need, whether or not the treatment is out there. So there's so many questions, and the homework, we don't know if it's being done, but because we don't have any answers yet. We'll see in committee stage.
Reprise de débat.
Resuming debate, the honourable member for Portneuf, Jacques Cartier. Thank you very much, Mr. Speaker. I'm proud to unite my voice to those of my colleagues to speak to Bill C54, which would amend the Criminal Code and the National Defense Act with regard to mental disorders. This issue was greatly discussed in the House today, but we all know that it raises a very important issue, but also a very sensitive one for victims and for all Canadians. Unfortunately, in almost every part of the country, in every community, there are tragic events which occur. I am not going to mention some specific cases, especially the one in Quebec, but suffice it to say that it's good to have a debate here in the House. However, what's unfortunate is that, again, today, the government has introduced a motion of closure to limit debate on a bill which is so important and which directly affects victims. So, at second reading, our time for debate has been limited. However, I hope the same thing doesn't happen in committee. That is, I hope that in committee we will not restrict the time of witnesses to speak, to talk about their experiences, to speak to this bill. On other committees, this government has taken advantage of its majority position to quiet the voices which do not agree with it. I certainly hope that the government will change its tune, because what's at stake here is really crucial. This bill was introduced following certain events which made headlines, and people, of course, were shocked at what had happened, rightfully so. Nevertheless, we need to take the time to conduct an in-depth study of this bill. Bill C54 would amend certain provisions of the Criminal Code in order to, amongst other things, make the safety of the public the primary consideration in the decision-making process taken by the courts and review boards with regard to people declared not criminally responsible. The bill would also create a mechanism which would put people declared as high risk under additional they would have to meet additional criteria if they would be conditionally discharged. The bill would also make more room for the families of victims. The changes proposed in Bill C54 are fairly significant, and they deserve to be studied more closely in committee. This is why I myself and my colleagues will support the bill at second reading. We believe that the Justice Committee should be able to study the various provisions of the bill, and that the committee conduct an in-depth and nonpartisan study. I think we can all agree here that this matter should not be the object of partisanship or political games. We have to make sure that we consult mental health experts, provinces, and victims to make sure that the approach we take will be the best possible here in Canada. We are all aware of the fact that the safety of the public must be a priority, but we have to make sure that this protection nevertheless respects both the rule of law and the Charter. And this is what our study in committee will allow us to do. It will also allow us to make sure that this bill respects the fundamental principles on which our country was founded. And these principles, of course, have to be reflected in every bill that we pass, be it a bill to protect victims or anything else. We must keep that utmost in mind. We also have to make sure that we're doing everything we can to support victims of criminal acts. This is one of our priorities. In fact, it's the priority of every party in this House. I think it can be said that We all here want to do everything we can for victims and to make sure that they are supported to the best of our abilities through this bill in the future to make sure that they can truly reintegrate society and overcome the trauma they have experienced. Certainly, it can be difficult, but all parliamentarians have the responsibility of putting these measures forward. We all know that victims are most directly affected by crime, and it is our responsibility to help them. There are already all kinds of compensation programs for victims and all kinds of services that are available, and these are essential. But the question we need to ask ourselves when we contemplate a bill like C54 is whether the measures contained in the bill will be enough to protect victims of criminal acts, to help to protect them from being re-victimized. Further, will the bill truly provide more support to victims of criminal acts? I certainly hope so, and I certainly hope that the studying committee will help us answer that question, help us dig deeper, because these matters are important to the NDP. Other elements should also be the focus of the work in committee, and I certainly hope that these elements will be top of mind after the 5 hours of debate in the House are up. In fact, there already are groups and mental health experts who are worried about the potentially bad effects this bill might have on Canadians who who suffer from mental disorders without breaking any laws. These citizens are law-abiding. They abide by the laws of the country, and they need additional support from the part of various governments. There have been various speeches on Bill C54, and it seems that some people who are declared not criminally responsible, or rather some people think that there are NCR people lurking everywhere in this country, but I think we need to have a reality check. Take Ontario, which is still the most populous province in the country. Only 0.0001% of people who are accused of violations of the criminal code, they have been found criminally not responsible. So it's an extremely tiny number. It doesn't mean we should sit on our hands and that we shouldn't seek to help victims more in the future, or that we shouldn't focus more on prevention in order to prevent more victims in the future. No, I'm saying that we have to keep in mind the impact these measures might have on other Canadians who are suffering from mental disorders.
Before being an MP, I completed a degree in psychology at the University of Laval, and I was able to see how people are stigmatized when they have mental disorders. These issues are still poorly understood by a large part of the Canadian population. For example, we see a common stereotype, which is that people who have schizophrenia are considered violent people. But very often, that's not the case at all. They do have certain challenges, but it's pretty rare for people who have schizophrenia to commit violent crime. We already have a number of services that are offered within the community, so there are a number of organizations that do excellent work. There's the Rainbow organization, which serves all of the people of Portneuf in my riding, and they try to break down the stereotypes we have in terms of mental health, and they offer different services to the public in Portneuf. So these are the issues I would like to see studied in committee, and that's why I support Bill C54 in second reading, and I look forward to seeing the results of the committee's work to ensure that we really have the best system in the criminal code to deal with individuals who are found not criminally responsible. Thank you.
Questions and comments? The Honourable Member for Vancouver Kingsway.
Thank you, Mr. Speaker. I'd like to congratulate my colleague and thank her for a really thoughtful speech on a very difficult subject. You know, when we're dealing with issues of justice in this country, where we're dealing with crimes that involve, I think, some of the most serious emotions and serious impacts on people that we can imagine, it behooves us as parliamentarians to move very prudently and cautiously, because what we need is an incredible balance here. We need a sensitive balance that recognizes the unbelievable pain that victims experience when they suffer from a crime committed against they or their loved ones. And we must also balance and temper that with a sense of justice for the person who has committed that crime, because the point of our criminal justice system is at the very end to do that, to do justice. And so I'd like to ask honourable colleague if there are any facts or statistics that were used by the government in crafting this law, or does she feel that this, like so many other conservative laws before them, this is a law that is more about politics and wedging than it is about coming to a thoughtful, effective criminal law?
The Honourable Member for Portneuf-Jacques-Cartier. I'd like to thank my colleague for his excellent question. It's difficult. This is a very serious subject. It's a difficult subject. It's difficult when we run into political issues, and unfortunately that's happening in this House all too often. One of my colleagues earlier, when we had the debate on the time allocation motion, I think it was the 33rd at that point, because we had a second one this afternoon, so now we're at 34. The government has decided to close debate, and it was my colleague for Gatineau who pointed out to the Justice Minister that the statistics he used to back up the bill weren't the right ones. Too often, we see the government make decisions that could be based on the media, what's found in the papers, very strong reactions that are taken at the surface following difficult experiences for families and communities. But here, well, I hope the committee will be able to overcome the shortcomings we see all too often in the preparation of this government's bills. Questions?
For Halifax.
Thank you. Thank you, Mr. Speaker. Speaking of political games, my question to my colleague is about political games when it comes to victims. As we all know, there's a bit of a scandal happening around expenses in the Senate. And I heard one of our conservative colleagues on the radio talking about, this is not what Canadians really care about. Canadians really care about keeping our streets safe and keeping pedophiles off the street. And I was like, really? We're talking about Senate expenses and you're talking about keeping pedophiles off the street? This is not what people are actually talking to me day to day in my riding. They're talking to me about things that are happening in their real lives. And so in that vein of creating this fear and creating this sense that all these boogeymen are out there to get us, and then creating public policy based on a couple of instances of tragedy which need to be addressed but don't necessarily create the best basis for public policy for all. I wonder where's the attention to victims here? Why don't we actually have funding for victims organizations, have funding for victims to be able to get on with their lives? That would be true attention to victims as far as I'm concerned. I wonder if she agrees.
The Honourable Member for Portneuf-Jacques-Cartier. I'd like to thank my colleague for her excellent question because she has summarized my point of view on this issue. Here, there are some provisions that would allow for greater victim involvement in the release process for people found not criminally responsible, but it's not direct help to help them overcome and survive the difficult experiences they've undergone. I was on the Public Safety Committee until just recently, and during our discussions, when we met with witnesses, we really saw the importance of prevention to avoid having new victims. And this is one aspect of the work that we often forget. People capitalize on shocking events But there isn't enough reflection, and we need more of that type of work in this House. We shouldn't simply have knee-jerk government reactions like we see all too often in this House.
Resuming debate, the honourable member for Kootenay, Columbia.
Thank you, Mr. Speaker. And before I start, I'd like to let you know that I'll be sharing my time with the honourable member from Crowfoot, and looking forward to his speech. Mr. Speaker, I'm very pleased to have the opportunity to speak on second reading debate of Bill C54. As a retired police officer, this is very close to heart with me. I've seen many cases where this has been traumatic on both sides, not only for the victims, but also for those that have been found not criminally responsible. This bill would reform not just the criminal code mental disorder regime, but also the corresponding regime in the National Defence Act to ensure these regimes develop harmoniously. This bill is very complex, not only from a technical and legal perspective, but also because of the sensitive issues that it seeks to address. At the heart of this bill is the complex matter of assessing the risk to public safety of people who have committed horrific crimes, who suffer from a mental disorder. Unlike convicted offenders, the mental disordered accused person is not held criminally responsible for their actions due to the presence of mental illness at the time of the commission of the offense that prevented them from knowing what they were doing or what it was that they were doing wrong. Mr. Speaker, this concept is not only difficult for many Canadians to understand, it is also difficult for many Canadians to accept. It is particularly difficult when a very tragic, horrific incident has occurred. Not criminally responsible accused are not held accountable and sentenced like convicted offenders are. Instead, they may be detained under the criminal law power if they pose a significant threat to public safety. Decisions about individuals found not criminally responsible are made by provincially constituted administrative tribunals known as review boards. The Criminal Code mental disorder regime guides review boards in their ultimate goal of protecting the public from mentally disordered accused who continue to pose a danger. Mr. Speaker, I would like to focus my remarks on the public safety elements of Bill C54. First, the bill clarifies that public safety must be paramount consideration. Again, it must be the paramount consideration in the decision-making factors that the courts and review boards apply when dealing with cases of mentally disordered accused persons. The goal of ensuring public safety animates the entire legal regime that applies to mentally disordered accused persons who are referred to the review boards. One could say that it is their raison d'etre as the review board's main task is assessing the public safety risk posed by a particular unfit or not criminally responsible accused and making orders to address those risks. In short, Mr. Speaker, it is appropriate to highlight public safety as being the paramount factor in the review board decision-making process. If there are no real risks to public safety, the legislation is clear in requiring that an absolute discharge is to be made. Another key public safety element of Bill C54 is the new hearing process for the courts to determine whether a particular not criminal responsible accused is a high-risk accused, and where so, imposing stricter rules of detention more tailored to protecting the public. Concerns have been expressed about the potential for day passes or passes longer in nature from a hospital being granted to a mentally disordered accused who, under the jurisdiction of the review boards, may pose a danger to society. In at least one recent case, an unescorted absentee from a hospital led to the killing of an innocent victim. This bill aims to prevent such tragedies from occurring. The proposed high-risk designation scheme is tailored to respond to situations where the risk to the public safety posed by certain not criminally responsible accused is considered to be greater and therefore requires greater protection. Designations could be made in one of two possible situations. First, when there is a substantial likelihood that the accused will commit further violence that could endanger the public, or second, where the offense that led to the not criminally responsible verdict was of such a brutal nature as to indicate a risk of grave harm to the public. Procedurally, the high-risk designation scheme would be launched by way of an application by the prosecutor to the courts after a not criminally responsible verdict has been rendered for a serious personal injury offense. An application could only be made if the accused has not already been absolutely discharged. However, if the accused is still in the review board system, whether in custody or subject to a conditional discharge, the Crown could bring an application, if it wishes, to obtain an order designating a particular accused as high risk. The court would consider all relevant evidence, including the nature and circumstances of the offense, any relevant pattern of repetitive behavior, the accused's current mental condition, the past and expected course of treatment, and the accused's willingness to follow treatment, as well as expert medical opinions. If the court makes the high-risk accused finding, a disposition requires detention of the accused in a hospital must be made. No conditions permitting absentees from the hospital would be authorized unless a structured plan has been prepared to address any risk to the public, and only with an authorized escort. Absences from the hospital would only be permitted for medical reasons and for any purpose that is necessary for the accused's treatment. I note, Mr. Speaker, that Bill C54 also mentions that decision makers, the court and review boards, shall consider whether it is desirable in the interests of the safety and security of any person, particularly a victim, to include a conditional requiring the accused to abstain from communicating with the victim or attending a specified place. There is also authority for any other condition to be made to ensure the safety and security of victims. These are very reasonable proposals, Mr. Speaker, and I'm pleased to see them included in this bill. I would like to commend the Minister of Justice for introducing this important piece of legislation. I would urge all members of this House to support passing Bill C54 at second reading, as this would enable further study of this bill at committee. As I mentioned at the outset, this is a very complex area of the law, and I'm sure that the task of assessing risks with respect to this population is very complex as well. I'm aware that the Department of Justice conducted its research on the review board systems in Canada. A research report on their data collected study was published in 2006 on the Department of Justice website. It contains a great deal of relevant statistical information, such as the nature of the offense that brought the person into the review board system, the nature of their diagnosis, prior involvement in the criminal justice system, types of decisions made, total caseloads, etc. No doubt this data will assist the Standing Committee on Justice and Human Rights when it studies the bill. Before closing, Mr. Speaker, I would like to take a moment to clarify an important point. Although Bill C54 addresses the difficult and sensitive issue of how to effectively manage the risk posed by accused persons who have been found by the courts to be not criminally responsible or unfit to stand trial on account of mental disorder, it should not be interpreted as a suggestion that all mentally ill people are dangerous. That is simply not the case. The debate around this bill must not lead to negative stereotyping about mental illness. To put things into perspective, it is estimated that 20% or 1 in 5 Canadians will suffer from a mental illness at some point in their life. This bill does not target the mentally ill at large. This bill deals with providing clear guidance on how those very few mentally ill accused persons who find themselves before the review board system should be dealt with in order to ensure that the safety of the public is adequately considered when there is significant threat to the safety of the public. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for North Delta.
Sorry, Newton. Thank you, Mr. North. Thank you, Mr. Speaker. Mr. Speaker, I asked the Parliamentary Secretary to the Minister of Justice earlier on in regards to the costs associated with this bill, and I didn't get a satisfactory answer to that. But I'm going to ask the honourable member if he can also enlighten that. My question is basically, with this bill, there is going to be costs that are going to be downloaded to the provinces. And we've seen this in many, many other bills where the bills is drafted and without any consultations with the provinces, then they are left holding the money. But basically, they have to provide all of the infrastructure. They have to provide all of the services that cost money to the provinces. So my question to the member is he aware if any consultations have taken place with the provinces in regards to downloading of the cost onto the provinces?
The Honourable Member for Kootenay Columbia.
Thank you very much, Mr. Speaker, for the question. Thank you, the Honourable Member, for his question. Not you, Mr. Speaker, I'm sorry. Certainly, consultations have been done with the province. We've held consultations with the province, as well as a number of individuals and organizations that specialize in law, victim services, justice services, and mental health services. In fact, our government has invested over $376 million in mental health research, and we've also established the Mental Health Commission. We are committed to ensuring that not criminally responsible people are taken care of to the best of our ability and to the ability of the provinces.
Questions and comments? The Honourable Member, the Honourable Parliament Secretary to the Minister of Justice.
Well, I'd like to thank the Honourable Member for his great work on the Justice Committee, and we know that the Honourable Member was an RCMP for many, many years, and I'm wondering if he could share some of how the experiences as an RCMP, how the strengthening of the bill, the Mental Act provisions of this bill would help in the field, because we know the officers end up dealing with these individuals day in, day out.
The Honourable Member for Kootenay Columbia.
Thank the Parliamentary Secretary for the question. Certainly, in my years as a police officer, I saw many cases where not criminally responsible people were involved in crimes, and some of those crimes, Mr. Speaker, were very horrific, and in fact, those people didn't know what they were doing. We have to be able to provide the services to those people to make them as good as we can, recognizing that some of them may need a lot of years of help to ensure that they can be integrated back into society and ensure that those people get all the help that they can from the best that are available.
Questions and comments? The Honourable Member for Burnaby New Westminster.
Thank you, Mr. Speaker. And as you know, we support the bill. We support the principle on providing support for victims. There's no doubt about that. Mr. Speaker, we've also asked a number of questions, and we as yet have not had the kinds of answers that should be forthcoming in terms of this legislation. Mr. Speaker, we support the bill, but we have seen a number of cases where bills that we've supported in principle have been poorly drafted, and as you know, Mr. Speaker, in a number of cases, because of court actions, the government has had to redraft the work that wasn't necessarily effectively done in the first place. So we'd like to get it right off, Mr. Speaker, and we have concerns around the fact that the government is bringing in closure, has not been able to answer a number of questions that have been asked by members of this House. So I'd like to ask the member, particularly in light of some of the concerns coming from provinces. We've seen significant cutbacks in crime prevention programs, Mr. Speaker. As you know, what that has meant is that municipalities and provinces have had to fill the void where the government has simply not provided the funding that's necessary. Can the member
Speaker, respond to the questions about the downloading to provinces. We want to make sure this legislation is done effectively.
The honourable member for Kootenay Columbia, short answer, please.
Thank you, Mr. Speaker, and thank the member for his question. Certainly, this government has recognized over the years the importance of health care to all provinces. In fact, we have increased the transfer payments to provinces to a total of $62 billion, nearly 50% increase since 2006. A significant amount of that money has gone to mental health, and we will continue to support the provinces in their efforts to ensure that mentally handicapped people and those not criminally responsible are brought to the best opportunities available to them to make them better.
Resuming debate, the honourable member for Crowfoot.
Well, thank you very much, Mr. Speaker, and I do appreciate the ability to stand in the House here this evening and discuss this bill that's been brought forward through the Justice Committee. I have the privilege of chairing the Public Safety and National Security Committee, and one of the things that I think all of us realize is the number of issues that arise around mental health issues, and we've seen it in the news, we've seen it at committee. We just understand that this is one of the issues that we have to deal with. I also want to say that this issue isn't just an issue of concern to members of Parliament. I think it's increasingly an issue of concern to many Canadians. The question that lies at the heart of this bill is how to ensure the public safety is paramount when decisions are made about individuals who have been found not criminally responsible for their criminal offences on the account of a mental disorder. This bill would amend the Criminal Code and the National Defence Act mental disorder regimes to ensure that public safety is the paramount consideration and that victims no longer feel left out of the process. The changes to the National Defence Act essentially mirror those being proposed in the Criminal Code to ensure that the public safety and victim-related improvements also apply when dealing with individuals who have been found not responsible for offences within the military justice system. I'm going to focus my comments this evening here on the elements of the bill that relate to victims. On the day the bill was introduced, the Prime Minister and the Minister of Justice emphasized that this bill aims to enhance victim safety and involvement in the decision-making process. It's important to make sure that our laws reflect those objectives explicitly and adequately. Mr. Speaker, the victims of individuals who are found not criminally responsible are concerned that inadequate consideration is given to their safety by the review boards when a decision is made regarding a mentally disordered person who has been accused of a criminal offense. Victims have also raised the concern about the fact that they have no way of knowing when an accused who was found not criminally responsible has been released or being given access back into their community. They are therefore afraid that they may encounter them unexpectedly and without being adequately prepared. Mr. Speaker, we know the damage that can be done when those type of instances take place. The ones who have been victimized, all of a sudden bumping into them at the neighbor grocery shop or wherever it may be in their community. Mr. Speaker, this bill, Bill C54, addresses these issues. I am very pleased to note that Bill C54 includes specific measures to better protect victims. The bill expressly provides that when a court or a review board decides on a course of action relating to a mentally disordered accused person, that the victim's safety is taken into consideration. That's the first thing, that they view this through the scope of the victim. In addition, the proposed reforms would allow the court or the review board to order that the person found not criminally responsible abstain from communicating with the victim. We know occasions where they just become re-victimized when the alleged offender or the one found not guilty because of the mental disorder, then begins a communication line with those very people that they have victimized. In addition to the reforms relating to victim safety, Bill C54 proposes amendments to improve notification to victims and enhance victims' involvement. The bill provides that at a victim's request, they will be informed when a mentally disordered accused person is being absolutely or conditionally discharged. Victims may also request to be informed of the holding of any hearing in respect to the accused, including hearings concerning any possible finding that an accused is high risk or revocation of such a finding. So this bill will increase awareness to society, but also certainly to the one victimized. Since some victims do not wish to participate in the hearings and thus relive the trauma of the incident, they have been given the choice of not requesting notice. But again, the victim decides. It's up to them to choose whether or not they want to appear or be made aware of any of these requests. The notice will enable victims to exercise their right to file a victim impact statement, if they desire, for consideration by the court or by the review board, outlining the harm done to them or the loss that they have suffered. And Mr. Speaker, I am very pleased to see how this bill adds to the government's many initiatives to meet the needs of victims. Since the federal victim strategy was announced in 2007, our government has supported many different measures to meet the needs of victims of crime, including enhancing the victim assistance program across Canada, and increasing the capacity of non-governmental organizations to deliver victim impact statements or to deliver victim services. Public safety measures, yes. This bill is full of public safety measures to make certain that the guiding principle of protection society remains the guiding principle. In addition to the specific measures, I'm pleased that the bill includes that. The Prime Minister stated on February 8, 2013, Canadians want a justice system that puts the safety of our communities and families first. The legislative amendments proposed in the Not Criminally Responsible Reform Act would clarify that the safety of the public is the paramount consideration in the court and in the review board decision-making process in respect of individuals found to be not criminally responsible on account of mental disorder or also if they are found to be unfit to stand trial. This bill would also amend the criminal code to create a process by which a court may find that a not criminally responsible accused is a high-risk accused. The court can make this finding with regard to a person who has been found not criminally responsible for a serious personal injury offense, where there is a substantial likelihood that they will use violence, that they will endanger the life or safety of another person. There are several effects of this high-risk designation. A high-risk accused would have to remain in hospital, and a review board would not be authorized to order a conditional or absolute release until a court has revoked the finding. Moreover, the review period for an accused found to be high risk would be extended for up to 3 years, whereas the general rule that a mentally disordered accused under the jurisdiction of a review board has his or her case reviewed on an annual basis. As well, the individual would only be permitted escorted absences from the hospital for medical reasons or reasons related to their treatment, and in accordance with a structured plan prepared to address any risk related to the mentally disordered accused absent from the hospital. Mr. Speaker, while this bill proposes to make important changes to the mental disorder regime, I feel that it is incumbent upon me to point out some things that the bill will not impact, because we have had already constituents call us in regards to some of these. For example, the bill will not impact in any way the access to treatment to which a mentally disordered accused has had access. The bill also would not impact the location of detention for mentally disordered accused. They would continue to be detained in appropriate mental health facilities and not in prisons. The criminal law governing persons found not criminally responsible on account of mental disorder is not well known. Part 20.1 of the Criminal Code comprehensively sets out the law and procedure governing persons found not criminally responsible on account of mental disorder and those found unfit to stand trial. This regime provides for both the supervision and treatment of mentally disordered accused as well as the protection of public safety. Another point I would like to make in closing, Mr. Speaker, is that although Bill C54 asks us to consider how to strengthen the law to ensure that it protects Canadians from actual threats to public safety, this is not meant to suggest that all people who suffer from a mental disorder commit criminal offenses and are dangerous. Some mentally disordered persons will commit minor, but others commit major violent offenses. Mr. Speaker, this bill helps to address these issues. It's timely. It's learned over the period of time that we needed to make changes. It's good to hear that our opposition is supportive of these measures as well.
Questions, questions and commentaires, l'honorable député.
The honourable member for Hochelaga. Thank you, Mr. Speaker. In answering a question of one of our colleagues earlier, his colleague suggested that there had been consultations with the provinces. So I'd be very curious to know what sort of consultations occurred, and some provinces were apparently consulted, and so were they in agreement with the fact that the provinces would largely be covering the bill for this bill?
Mr. Speaker, this type of legislation moves forward. I think we've been able to, first of all, address a situation, and then our minister always works closely with his attorneys general in the many different provinces. There's been many different cross-country consultations. A lot of this legislation comes really from concerns that are brought to the government. It's not that the minister is sitting back thinking, what can we bring forward in legislation? This is reactive to many different issues and of course, to many different stories in the news where we see that these are the issues that provinces and all of across Canada are concerned about. Some provinces and territories expressed concern in lead up to this legislation that public safety was not the guiding principle and that more needed to be done around the area of the mental health issues. Let me tell you, Mr. Speaker, that in our committee, we realize that our prisons are full of individuals who really, they need to have some type of help for mental disorder. And, you know, years ago, our provinces stepped back in some respect to certain institutionalization of some of these, and we find them in many of our prisons. We need to find ways that we can find the proper therapy for those who are suffering from these kind of illnesses, but we also need to make certain, as of the provinces expressed to us, that public safety remain the guiding principle.
Questions and comments? The honourable member for Winnipeg North.
Thank you, Mr. Speaker. And you know, I listen closely to in terms of what the member was talking about, and he emphasizes victims and reinforces victims. And I want to share with him a concern that residents of Winnipeg North, and I believe they share that with all Canadians, and that is that the government is not doing enough in terms of preventing victims, preventing crimes from taking place in the first place. And when you look at it from that perspective, the government neglect in that area is allowing for more victims of crimes to occur. And this is something that's really important to the constituents in which I represent. They want to see a government that takes more of a proactive approach at dealing with things such as diverting youth out of gangs and into more creative, positive atmosphere. And it seems to me that their focus is too narrow in its scope. And my question to the member is, can he indicate to the House when it is, or if at all, the government has any clear intention on dealing with issues specific to preventing crimes from taking place in the first place. What bold new initiatives can we anticipate in the next few months dealing with that issue?
The honourable member for Crowfoot.
Well, thank you very much, Mr. Speaker, and I appreciate the colleagues' the question. It's a good question. I can tell you right now that our committee is traveling across the country and looking at best practices. Last week they were in Prince Albert and Calgary and other places as well. And you know, many of the things that they found is that we need a community reaction, not only a knee-jerk reaction, as someone earlier said, but that we need to work with all different aspects of the community: mental health, health care, this education system, all those. And so I think we're seeing more and more where our government is working on strategies and plans to bring people together to prevent. This has come out in our committee. I think your member and all members are understanding that. But let me tell you what this government has done. When we came in 2006 and were first elected, we created a mental health commission. It wasn't there before. We invested over $376 million in mental health research because we realized that it wasn't just about health care, it was about the justice system, it was about the public safety, it was about all those things. And, Mr. Speaker, we have continued to work with the provinces in areas where we say, how can we network better? How can we find the therapy and the help that these people need in order to prevent recidivism? And that word recidivism is a big word when we deal with mental health.
Resuming debate, the Honourable Minister of Natural Resources.
Thank you, Mr. Speaker. I'm speaking tonight in full support of our government's decision to introduce the Not Criminally Responsible Reform Act, also known as Bill C54. Consistently since 2006, our government, under the strong leadership of the Prime Minister, has always championed tackling crime by holding violent criminals accountable for their actions, giving victims of crime a stronger voice, and increasing the efficiency of the justice system. To date, the government has achieved over 30 significant accomplishments in further to these objectives. Many of these accomplishments are embodied in the Safe Streets and Communities Act. There are numerous measures in that act, but allow me to highlight just a few. The Ending House Arrest for Property and Other Serious Crimes amendments restricted the use of conditional sentences, including house arrest, to ensure that this tool is used appropriately and provides clarity on the list of offences covered. The Safe Streets and Community Act also amended the Controlled Drugs and Substances Act to address serious organized drug crime. The CDSA now provides mandatory minimum penalties for serious drug offences, including those carried out for organized crime purposes and those that involve targeting youth. The legislation supported the National Anti-Drug Strategy's efforts to combat illicit drug production and distribution and help disrupt criminal enterprises by targeting drug suppliers. The Protecting Children from Sexual Predators component amended the criminal code to better protect children from sexual predators. It achieves that by ensuring that the penalties imposed by sexual offences against children are consistent and better reflect the heinous nature of these acts, and by creating 2 new offences that take aim at conduct that could facilitate the sexual abuse of a child. These are just a few of the important measures that this Act helped make Canadians safer and got tough on criminals. While our government has been clear that we're getting tough on crime, we've also taken action to improve victims' rights in the justice system. While there are numerous examples of our government's approach, including the Citizens Arrest and Self-Defense Act and the Protecting Victims from Sexual Offenders Act, I would like to focus on a few initiatives. First, our government's federal victim strategy has been a great success and ensuring that victims' rights are respected. The objective of the federal victim strategy is to give victims a more effective voice in the criminal justice system. The Department of Justice works in close collaboration with other federal institutions, as well as victims, victims' advocates, provincial and territorial governments, service providers, and others involved in the criminal justice system. The Department of Justice develops policy and criminal law reform, funds various programs to meet the needs of victims of crime, and shares information about issues of importance to victims of crime. Within the federal victim strategy, the Victims Fund is a grants and contributions program administered by the Department of Justice. Funds are available each year to fund provinces, territories, and non-governmental organizations whose projects, activities, and operations support the objectives of the federal victim strategy. Since 2007, when the government introduced the federal victim strategy, more than $90 million has been committed to respond to the needs of victims of crime. Most recently, in the Economic Action Plan 2012, the government committed an additional $5 million over 5 years for new or enhanced child advocacy centres, bringing the total Government of Canada commitment to these centres at $10.25 million. Child advocacy centres aim to minimize the trauma of being a child victim of crime. These centres are a collaborative team of professionals who work in a child-friendly setting to help a child or youth victim or witness navigate the criminal justice system. The work of the staff can greatly reduce the emotional and mental harm to the child. Furthermore, we instituted the Office of the Federal Ombudsman for Victims of Crime as an independent resource for victims in Canada. The office was created in 2007 to ensure that the federal government meets its responsibilities to victims of crime. Victims can also contact the office to learn more about their rights under federal law, and this service is available to them, or to make a complaint about any federal agency or federal legislation dealing with victims of crime. In addition to its direct work with victims, the office also works to ensure that policymakers and other criminal justice personnel are aware of victims' needs and concerns, and to identify the important issues and trends that may negatively impact victims. Where appropriate, the Ombudsman may also make recommendations to the federal government. Under the leadership of the Prime Minister, we're extremely proud of our record, and we continue to improve it. Which brings me to today's topic, Bill C54, the Not Criminally Responsible Reform Act. Before I begin describing the important measures in this bill, allow me to explain a few key concepts. Under the current Canadian criminal law, if the accused cannot understand the nature of the trial or its consequence, and cannot communicate with his or her lawyer on account of a mental disorder, the court will find the accused is unfit to stand trial. Similarly, if a person is found to have committed an offence but lacks the capacity to understand what he or she did or know what was wrong due to a mental disorder at the time, the court will make a special verdict of not criminally responsible on account of mental disorder. In either case, whether the accused is unfit to stand trial or is not criminally responsible, the appropriate provincial or territorial review board may take one of three actions. It could place the accused in hospital detention within custody, grant a conditional discharge, or grant an absolute discharge. Bill C54 amends the Criminal Code by emphasizing three primary objectives. It explicitly places public safety first. It creates a new high-risk designation, and it enhances victim involvement. First, the current approach has public safety as one of four factors. This legislation will clarify that the highest priority of this government is to keep Canadian citizens safe. It does this by explicitly making public safety the paramount consideration in the decision-making process relating to an accused found to be unfit to stand trial or not criminally responsible. We are also codifying what is meant by the term significant threat to the safety of the public. This test determines whether a review board should continue to supervise the accused. Some provinces have told us that they believe the review boards are interpreting this term too narrowly. Our approach will codify it along the lines of its interpretation by the Supreme Court of Canada. It would clarify that the review board can continue to impose restrictions on a not criminally responsible accused who risks committing further criminal acts, even though he or she does not pose a threat of violence per se. For example, if the board is concerned about a not criminally responsible accused committing thefts or break-ins, it would be able to maintain jurisdiction over him or her and impose the necessary and appropriate conditions. Second, the creation of a new high-risk designation is absolutely necessary. Such a designation would classify an accused found not criminally responsible for a serious personal injury offense who poses a substantial risk of committing further violent acts as a high-risk accused. It is important to note that this high-risk accused designation only applies following a verdict of not criminally responsible, rather than one who is unfit to stand trial because the latter has not yet been tried for the offence. The process would allow the prosecutor to apply to the court if the criteria were met. Once designated, a high-risk, not criminally responsible accused will be held in custody and not considered for release until the high-risk status is revoked. The high-risk accused may have his or her review period extended up to 3 years if the accused consents or if the board is satisfied that it would be highly unlikely that the individual's condition will improve in that time period. The annual review will continue to be available for all other not criminally responsible accused persons. Bill C54 outlines that a high-risk, not criminally responsible accused person would not be allowed to go into the community unescorted. And escorted passes would only be allowed in narrow circumstances and would be subject to sufficient conditions to protect public safety. Third, victims are concerned that their safety is not being specifically taken into consideration by review boards when they make a disposition. Victims are also concerned that they often have no way of knowing if and when a not criminally responsible accused will be given access to the community, and they're afraid that they would unexpectedly run into the person who injured them without being adequately prepared. The proposed legislation will enhance the safety of victims and provide an opportunity for their greater involvement in the criminal code mental disorder regime. The legislation will help ensure that victims are notified upon request when a not criminally responsible accused is discharged, allow non-communications orders between a not criminally responsible accused and the victim, and ensure that the safety of victims be considered when decisions are being made about a not criminally responsible accused person. The proposed legislation builds on actions that have already been taken to further advance the interests of victims of crime. While it is important to know what is in this bill and how it will further strengthen our justice system, it is also important to know what is not in the bill. First, nowhere in this bill do we seek to impose penal consequences on people who are found to be not criminally responsible due to mental disorder. The goal of this bill is public safety and protecting Canadians from those who pose a danger. Our current public safety objective is the basis of our legislative regime on mental disorders, and this bill further strengthens that objective. Second, there are no changes that would impact the ability of the accused to access mental health treatment. Issues surrounding mental health are prevalent in the criminal justice system and pose special challenges to law enforcement officials. We remain committed to ensuring that these challenges are addressed through the criminal justice system. Finally, it is important to note that this bill does not apply to all individuals who have a mental illness in the court system. These provisions only apply to those individuals who are unfit to stand trial or not criminally responsible due to their mental disorder. Those individuals who have not been found unfit or not criminally responsible are dealt with in the traditional criminal justice system. Our government recognizes that mental health is a serious issue that needs to be addressed. Our intention is to strike a better balance between the need to protect society against those who pose a significant threat to the public and the need to appropriately treat the mentally disordered accused. Our government continues to place a high priority on mental health initiatives. Our achievements include establishing the Mental Health Commission, investing over $376 million in mental health research, and continuing to work with the provinces. Mental health issues have been a focus of cooperative work among federal, provincial, and territorial ministers of justice and public safety. In a meeting in November 2012, the ministers acknowledged that persons with mental health issues present significant challenges for the justice system and especially for correctional systems, and agreed that close collaboration is required between jurisdictions in order to better address the needs of the mentally ill. We continue to take concrete steps on the issue of mental health in prison, and since 2006, we've invested nearly $90 million in mental health for prisoners.
I will summarize this bill, which has three main sections. First of all, public safety is the primary consideration in the decision-making process with regard to persons declared not criminally responsible. Under the bill, there would be a new declaration whereby the public would be protected against individuals designated as high risk. And third, the bill would also enhance victims' involvement. They would be given special attention when decisions are made with regard to accused persons declared not criminally responsible. They will be notified when an NCR accused is discharged, and the bill will also allow for non-communication orders between an NCR accused and the victim.
Our government has been clear that we put victims first. We've taken action to improve the justice system in this important regard. We've taken the action necessary to get tough on crime. Unfortunately, the opposition have opposed us at every turn. I hope that all members will see that Bill C54 is a step forward in the right direction. It is demanded and expected by law-abiding Canadians, and our government is responding by supplying this necessary legislation. It places the protection, well-being, and safety of Canadians first. It creates a high-risk designation of not criminally responsible accused, and it empowers victims of such crimes. I'm a strong supporter of Bill C54, and I encourage my House colleagues and the whole Parliament to demonstrate their support in achieving and maintaining these objectives for Canadians. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Montmorency, Charlevoix, Côte-Nord. Thank you, Mr. Speaker. From the outset, I would like to say that we accept the spirit of the bill and we would like to study it more in depth. However, We have questions, and I would ask the member to perhaps answer a question I have specifically with regard to the bill. It's all very well and good to adopt bills. It's all very well and good to act like Father knows best. However, is there going to be, are there going to be enough financial resources to go along with this bill? If provinces will end up paying the bill, is this something the government has thought about? That is, whether there will be costs which the provinces will incur. And if that's the case, will the federal government help the provinces pay for these costs?
Natural resources.
Mr. Speaker, this bill has been developed in consultation with the provinces across the country, and they're fully aware of the financial and other consequences that would flow from this bill. They're also, of course, supportive of our overarching objective of protecting the public, and there are positive consequences to that as well as the equity involved in protecting victims, something which needed to be addressed and is a continuing issue in this country.
Questions and comments? The honourable member for Renfrew, Pembroke, Nipissing.
Thank you, Mr. Speaker. A number of parents over the years who are adoptive parents of children with fetal alcohol syndrome have asked that when their children, then adults, get into trouble, if they would be incarcerated separately from the rest of the population. We heard how there's a concern over the provinces having money, but right now, until some of these people commit a crime, there is no access to mental health treatment. In Ontario, we see they blow $1 billion on moving a gas plant to get a couple of candidates elected. So my question to the minister is whether or not this bill will make provisions to ensure that the people who have suffered all their lives from fetal alcohol syndrome will get the treatment that they need, as well as not being put in with the general criminal population.
The Honourable Minister of Natural Resources.
The bill is designed, of course, to protect the population against people who pose a risk. And in this case, we don't see that as being an issue. The government has devoted significant amounts of money to the issue of mental health, and is concerned, of course, about this issue in particular. And I can give assurances to my colleague that that issue is being addressed.
Questions and comments? The Honourable Member for New Westminster, Burnaby.
Burnaby, New Westminster. Thank you very much, Mr. Speaker. The Minister spoke of the bill itself, which we support in principle. C54 we're supporting at second reading. We've had a number of questions that have come from the NDP that have remained unanswered. And unfortunately, though I followed the Minister's speech with interest, he wasn't able to respond to any of those questions either. And Mr. Speaker, this is somewhat worrisome because we want to make sure that this bill supports victims and the bill does what it purports to do. And so we have asked these questions. They still remain unanswered. And since we have a minister from the Cabinet, I have to ask the question in regards to this legislation and other legislation that the government has brought forward. Mr. Speaker, twice this House has voted to bring in the Public Safety Officer Compensation Fund. Twice now. Cabinet has refused to bring in that support. These are victims, firefighters and police officers who die in the line of duty, and there is nothing that is available to them to support their families. So I'd like to ask the Minister, through you, Mr. Speaker, why the Cabinet has now overruled 2 votes of the House on this, and why this legislation and other legislation does not bring in a Public Safety Officer Compensation Fund.
Before I go to the Minister, I just would like to remind all honourable members that their questions and comments ought to be related to the matter which is before the House, rather than other related matters. Having said that, I will allow the Minister to respond if he wishes. The Honourable Minister of Natural Resources.
Well, Mr. Speaker, you actually spoke for me in that regard. This is not the subject of today's debate, and I would refer the honourable member to my colleague, the Minister of Justice.
Questions and comments? The honourable member for Don Valley East.
Don Valley West. Thank
Don
you,
Valley
Speaker.
West.
I appreciate it. I want to comment on the minister's presentation. I think he's covered the bill well, and I appreciate his presentation tonight. And I wonder if he could just talk to. He spoke about victims' rights and some of the victim concerns that the government has as a foundational principle to this bill. And I wonder if he could just specifically address what some of the victim concerns were that were raised during the research on this bill.
The Honourable Minister of Natural Resources.
Mr. Speaker, I thank the honourable member from Don Valley West for his question, which really goes to the heart of one of the critical objectives of this bill. Victims are concerned that their safety is not being specifically taken into consideration by review boards when they make a disposition. Victims are also concerned that they often have no way of knowing if and when a not criminally responsible accused would be given access to the community, and they can frequently be concerned, indeed afraid, that they would unexpectedly run into that individual without being adequately prepared or without the opportunity of avoiding the encounter. The proposed legislation will enhance the safety of victims and provide an opportunity for greater involvement of victims in the criminal code mental disorder regime. The legislation will help ensure that victims are notified upon request when a NCR accused is discharged, allow non-communication orders between an NCR accused and the victim, ensure that the safety of victims be considered when decisions are being made about NCR accused persons. And the proposed legislation builds on actions that have already been taken to further advance the interests of victims of crime. These actions include the creation of the Office of the Ombudsman for Victims of Crime and the introduction of legislation to double the victim's surcharge.
Questions and comments? I'll try to get this one right. The Honourable Member for Surrey North.
Great. Thank you, Mr. Speaker. Mr. Speaker, I had a chance to talk to a service provider in my riding on the weekend, and they actually provide services to people with mental illness and also homeless people in my contingency of Surrey North. And one of the things they mentioned was that they lack resources. They lack resources for treatment, for prevention, and that is what works. We've seen research after research after research that if we pour 1/10 of the money into prevention and also for treatment, it pays dividend by many-fold over time. So I know this bill talks about punishment. Can the minister maybe tell us if any additional funding is going into prevention and also treatment for mentally ill in our society?
The Honourable Minister of Natural Resources.
The first point is this bill does not talk about punishment, and I regret that the member opposite missed the basic thrust of the bill. Transfer payments to the province will total $62 billion this year, nearly a 50% increase since 2006, since we formed government. And so it's our intention to strike a better balance between the need to protect society against those who pose a significant risk to the public and the need to treat the mentally disordered accused appropriately. And our government continues to place a high priority on mental health initiatives. Our achievements include establishing the Mental Health Commission, investing over $376,000 in mental health research, and continuing to work with the provinces. Mental health issues have been a focus of cooperative work among federal, provincial, and territorial ministers of justice and public safety. In a meeting in November 2012, the ministers acknowledged that persons with mental health issues present significant challenges for the justice system and especially for correction systems, and agreed that close collaboration is required between jurisdictions in order to better address the needs of the mentally ill. We continue to take concrete steps on the issue of mental health in prison, and since 2006, we invested nearly $90 million in mental health for prisoners.
Resuming debate, the honourable member for Toronto Centre.
Thank you, Mr. Speaker, and I take this opportunity to say that I'll be sharing my time with my colleague from Vancouver Centre. Mr. Speaker, I find myself in the, I suppose, not unusual position for me, but nevertheless one where I'm swimming against the tide. I have no doubt at all that there is a need for us to take the issue of victims and victims' rights very seriously. And I think if we were to look back at how the law could be improved, this would be one area where I think we can all agree. But when I look at the legislation overall, and in the discussions that I've had over the last several weeks with a number of groups involved with the issues of mental health and mental illness, I find myself unable to recommend to my colleagues that we vote in favor of this legislation, even on second reading. And I know when I say that there will be members who will be struck in disbelief and others who will be saying, well, surely you recognize that dangerous people should be kept off the street. And my answer to that is, of course, and they are. The fact of the matter, the facts are these, Mr. Speaker. The defense of insanity, the recognition that people who are not able to judge the consequences of their acts and are not able to say whether they're right or wrong, and are found to be either not able to even to stand trial or else are found to be not criminally responsible, has been a foundation of our criminal justice system in the common law world for hundreds of years. It is a basic principle of the criminal law that people who can understand the consequences of their actions and have the necessary intent should be found to be criminally responsible, and others have to be treated in a different way, not simply set free, as some in the sort of use of stereotypes might like to make people believe, but rather are kept away from society and today, as we try to deal with these issues, hopefully treated and rehabilitated in such a way that they're able to be reintegrated successfully in society. And it was Madam Justice McLaughlin who, in consideration of a case before the court, said, before she became Chief Justice, she said, treatment and not incarceration is necessary to stabilize the mental condition of a dangerous NCR accused and reduce the threat to public safety created by that condition. That was in the so-called Winco case. Mr. Speaker, until the early 90s, the rule was that you were held at will under a lieutenant governor's warrant. Lieutenant governor established in the provinces a review committee, but there were really no clear criteria that established how would incarceration suddenly end. And it was in response to a decision of the Supreme Court in the Swain case that said that the protection of the public was not guaranteed by that practice, that then said we have to establish a new system. And the basis of the new system was to say we're first of all not punishing people because they're not capable of being punished. And I'm glad that the Minister of Natural Resources emphasized that in the speech that he gave. We're not punishing people. We are incarcerating people for the protection of the public. Yes, of course, public safety is an absolutely important concern that we all have and all share. No one wants to see public safety in any way, shape, or form compromised, but also to allow people to become rehabilitated because they were not capable of understanding what they were doing. And we want to put them in a condition where they're going to be able to understand what they're doing. And understand, of course, that this is an area of life that's full of fear and insecurity, of mythologies and misunderstandings, and in which it's only too easy from time to time to say, we have a hot button, let's press it. I certainly believe, Mr. Speaker, and I share entirely the comments that have been made by members of both the Conservative and the New Democratic parties, that it is entirely legitimate for us to take the concerns of victims far more seriously than we have done in the past. And I can say, as somebody who's been in government, have made every effort to do that when it was important for us to do that in terms of victim statements and courts taking what's happening to victims much more seriously than they have. But we also have to understand, Mr. Speaker, that we live in a society that's governed by the rule of law, in which you cannot incarcerate people indefinitely without providing for due process, which is what the court told us in 1991. There has to be due process. And the government will argue that, well, we provided for due process and the process that we're establishing is perfectly adequate. And I have to say to the government, I'm not sure you've been able to do that. In fact, I've recommended strongly to my colleagues when I was in a position to recommend something to my colleagues, that we, in fact, not support this legislation, although I knew, and I said to them, this will not be politically popular. This will not be a winner with people, because when you press a button like this, you will get a response from the public. But I say to my colleagues in the Conservative Party as well as in the New Democratic Party, both parties are now supporting this legislation, let's not manufacture a crisis which does not exist. There is no crisis in public safety. It doesn't exist. The evidence is not there that justifies the sense that if you've been committed a horrible crime and you are mentally ill, that you are any more likely than anyone else to commit that crime again. In fact, the opposite. The rate of recidivism for those people who found to be not criminally responsible is 4% for those people who've been given an absolute discharge. For people who've left prison, it's 44%. And the fact of the matter is you can't incarcerate people indefinitely. You have to have a process which respects the rights of the individual as well as the rights of society. That's the balance we have to strike. Naturally,
Mr. Speaker, there will be difficult situations. There will be emotional situations. We can see that. But people with a mental disorder, which is connected with a serious crime, are not criminals. And the Liberal Party did not invent this principle. This is a principle that is founded on natural justice of our society and has been for a long time, which is why, Mr. Speaker, I say that we must ensure a balance, which we don't see in this bill. And therefore, we cannot support it, unfortunately.
Particularly the last few years of my political life, campaigning really for people to understand better the nature of mental illness, the importance of getting rid of stigma, the importance of understanding that the mad individual is not necessarily, and in all circumstances, somebody who is to be incarcerated for an indefinite period of time. And for us to understand that we've gone through a steady evolution over the last 100 years in understanding how important it is to treat, yes, the causes of crime, just as truly as we treat crime itself. If I believe that our current legislation denigrated the importance of public security and public safety, I would agree with the government and I would agree with the New Democratic Party. But that simply isn't the case. It simply isn't the case to say that these review boards are conducting their work as if public safety was of no concern or of no consequence to them or to anyone else. I think we've allowed certain mythologies, certain stereotypes to take over, and we're failing to recognize the real risks that apply to this legislation. I was interested that Mr. Sapers, who's the Corrections Investigations Officer for the country, expressed concern about this legislation, saying, in fact, it would increase the number of people who are mentally ill in jail and not decrease that number. Mr. Speaker, I may, at the risk of being even further stereotyped by my colleagues in the other way, say this. Shakespeare said it best, "The quality of mercy is not strained. It droppeth as the gentle rain from heaven upon the place beneath. It is twice blessed. It blesseth him that gives and him that takes. 'Tis mightiest in the mightiest. It becomes the throned monarch better than his crown. His scepter shows the force of temporal power, the attribute to awe and majesty, wherein thus sit the dread and fear of kings. But mercy is above this sceptred sway. It is enthroned in the hearts of kings. It is an attribute to God himself. An earthly power doth then show like as God's, when mercy seasons justice. Let us never forget, colleagues, that mercy must season the justice that we seek. Thank you, Mr. Speaker.
Questions and comments? Honourable Parliamentary Secretary to the Minister of the Environment.
Well, Mr. Speaker, since we're quoting this evening, I may say less art, more matter. And if one is going to talk about mercy and one is going to quote the figure of 4% acceptability, I ask my colleagues this. Is he assuming that there is an acceptable limit or a floor in which the circumstances that we're trying to prevent in this bill becomes acceptable or merciful? I don't think that that's the case, Mr. Speaker, and I would implore him to really think quite carefully about his answer. As those 4%, the people who are impacted by this have just as much rights as those that he spoke against this evening, Mr. Speaker. And I would argue in this place that that is the definition of mercy, and that's why this bill is worthy of study. So I'd ask him to explain what rights the 4% have.
The Honourable Member for Toronto Centre.
Speaker, if we follow down the path that the member from Calgary is suggesting we should follow, the logic would be that we would never let anybody out of prison at all, ever, if we ever thought there was any risk whatsoever of them recommitting an offense. The fact of the matter is that those who are found to be criminally responsible for their crimes, even under all the changes to the criminal code that their members opposite would like to make, eventually they're going to be released. And what do the statistics show? The statistics show that for those people, the rate of likelihood of recommitting a crime is 44%. What I'm suggesting is that the stereotype that says that the person who's been found not criminally responsible is likely to recommit, that stereotype is false, and the evidence doesn't support it. And the premise of the Conservative bill, which is unhappily, I must say, being supported by the New Democratic Party, that somehow the current system is broken and that there are dangerous, crazy people running around that we have to lock them up for even longer, that stereotype is completely false, Mr. Speaker.
Questions and comments? The Honourable Member for Edmonton Centre.
Well, thank you very much, Mr. Speaker, and this is a good discussion. And I'd ask my honourable colleague from Toronto. He was talking about 44% recidivism of prison population at large. What percentage of those are people that have committed the kind of heinous crimes that we're talking about, that we're concerned about with the 4%? And I don't know what that number is. I don't know whether my colleague does or not, but I think there needs to be some perspective here in terms of the kind of crimes we're talking about for the not criminally responsible that we're most concerned about versus the broader prison population that has the 44%, and I accept his numbers, recidivism rate. Is there some perspective there?
The Honourable Member for Toronto Centre.
He is a friend. I say on the floor of the House, he's a friend of mine. I say to my colleague from Edmonton, I say this: there is no system that you can invent, even the one that you're creating, where you add the category of a high-risk crime, where you add the additional factors that the review board has to consider. People will still be allowed out. Eventually, they're going to be allowed out once they're able to convince people that, in fact, they're better and are not likely to commit another crime. And who knows? There is no perfect system which says that in this system, none of those people will ever commit another crime. The other thing you have to understand is that when we talk about the high-risk situation and we talk about the heinous crimes, not every person who's found to be not criminally responsible is guilty of a heinous crime. There are horrible crimes. Some of them are committed by people who were found to be criminally responsible, and some of them are committed by people who are found to be mentally ill and not capable of understanding their actions. In both cases, we want to establish a system that does everything possible to see that people are rehabilitated and not likely to do it. I don't think this adds to the protection of the public. If I thought it would, I might change my mind.
Before we resume debate, just want to remind all honourable members if they could direct their comments to the chair rather than directly to their colleagues. Resuming debate, the honourable member for Vancouver Centre.
I wanted to say that my colleague from Toronto Centre said that he's advising us not to support this bill, but I think that we as Liberals will be voting against this bill on some basic premise. The premise being that C54, which is the Non-Criminally Responsible Reform Act, will not achieve the desired result. Instead, it will cause more harm than good and further stigmatize the mentally ill at a time when the good work of the Mental Health Commission of Canada has begun to undo that misinformation with good evidence and encourage mentally ill people to seek the treatment and the early diagnosis that they need. And I think this is the most important thing that we want to stress here. This will send mentally ill people back underground, because they will be terrified of being stigmatized in the way that they used to in the past. I think, Mr. Speaker, Liberals agree fully that the rights of the victims should be enhanced. We have no problem with that part of the bill, and we agree that public safety is of the utmost importance and is a core part of the justice system. We, again, have no problem with the issue of public safety, but our concern lies with the lack of balance in this bill. The designation of high-risk offender for a person who has been not criminally responsible creates a fear of the mentally ill. Because the point to remember is that when you look at the data, Mr. Speaker, only 2% of 0.2% of all criminal cases in the courts, any criminal case at all, is an NCR person. And 10% of that 2%, that's 0.02%, are violent offenders. We are talking about a very, very small number of people, Mr. Speaker, and I think this is the kind of problem that we don't want to see cause this knee-jerk reaction to something, creating legislation that's going to do more harm by trying to deal with a problem that, in fact, has been dealt with already in a manner that has been shown to be successful with some tweaking here. We agree that there needs to be some enhancement of the bill. However, what we would like to see, Mr. Speaker, is evidence-based approach that would incorporate the experience and the expertise of professionals in the field of mental health and justice. Our approach would enhance public safety by focusing on the prevention of violence by individuals with severe mental illness. And that means early diagnosis, Mr. Speaker. So a lot of time should be spent in catching young offenders and diagnosing them before they offend. Many instances of NCR cases who commit violent crimes are people who did not know and suddenly had a crisis and in fact became very severely incapable of being criminally responsible because they became a schizophrenic or they had an acute episode of manic depression or something that caused them to do that violent act. So, Mr. Speaker, we would also like to see this intervention and treatment as part of a good, solid bill that's going to deal with this issue. And rather than adding to the stigmatization of the mentally ill by using a small number of high-profile cases to foster the impression that Canada is overrun with dangerous psychopaths, I think we would like to reduce the stigma. And we would like to encourage Canadians suffering from severe mental illness to seek treatment. And if you keep the stigma up, people with mental illnesses do not want to seek treatment, and that has been the whole problem over all the years and why the Canadian Mental Health Commission has actually stepped in to deal with this issue. And this government has repeated over in the House. We want to decrease stigmatization. Well, this bill is going to do the exact opposite. In fact, the mental health groups, all of whom claimed that they had never been consulted by this government, despite the minister saying that he had consulted them, feel very strongly about this issue. And in fact, Mr. Speaker, I'd like to quote the Mental Health Commission of Canada, which is created by the federal government, says that, in fact, this bill paints an inaccurate picture of violence and mental illness, and that the more mental illness is stigmatized, the harder it is to get people to seek and stay in treatment. Yet treatment is the most effective measure for the small number of people with mental illness who commit violent offenses. So here we have the Mental Health Commission of Canada, whom this government has mentioned on many of the speeches, saying that they did not necessarily approve the bill. Let's look at the evidence. As I said earlier on, non-criminally responsible offenders make up only 0.2% of all criminal cases. And only 10% of that 0.2%, which is 0.02%, are actually violent offenders. So we are talking about a very small group of people here. When appropriately treated, these offenders, their offending rate or recidivism rate is actually 7% when they're properly treated. But if they're not treated in a mental institution and if they're not appropriately treated, actually their recidivism rate becomes increasingly high, and we look at something like 63% if they're sent into a mental institution. And I ask you to think about it and compare 7% recidivism rate when properly treated and a 63% recidivism rate when put into the criminal justice system and in prison. So I just wanted you to look at what you can do, because the problem here, and we've heard this said before by the Bar Association and by many people, is that if you are going to force people who are mentally ill into this mandatory 3-year treatment in a hospital before they get any ability to leave, what you're going to do is have lawyers tell their patients not to ask for an NCR designation. In other words, these people will therefore go into the courts and they will be put into the criminal justice system, they will be put into prisons, and therefore we will see that the damage will have been done and that recidivism rate will rise to 63%. So we're talking about a bill that can damage and can cause more harm than good, and I want to stress that, Mr. Speaker. Now, you know, the point here is the recidivism rate of all persons released from any kind of federal custody in terms of the criminal justice system and prisons is 46%. That means all people, not just people with violent crimes. And so the key here is recognizing that an NCR offender, by being put into the appropriate criminal treatment facility as opposed to prison, will actually be able to achieve the kind of treatment that they require, the ability then to go out and to be rehabilitated. And I think this is some of the problems that everyone wants to talk about here, that in fact the public fear of people who have been NCR and who have been treated and who are going through their actual community rehabilitation are out on the street. And I think this concerns people. And I think this can be easily looked at, in spite of evidence, that we can make sure that every time this community rehabilitation occurs and the prisoner is out in the community, that there is a custodian with them, that they are actually there with someone who's looking after them so that they're not alone in the system. And I think that would help to bring down the kind of public fear that we're talking about. But let us look at the system currently, Mr. Speaker. When someone currently is NCR and they are put into the appropriate facility, which is a mental hospital, then what we find is that these offenders have a yearly review right now. That's how it goes. Every year they're reviewed, and in fact that is done by a review board. And this has worked very well in the past. A review board has psychiatrists and other people who then decide whether the person has been cured and is ready for the next stage in rehabilitation, so that the public safety is assured that they do not go out there into the public until they're ready to go out into the public. Now, if people are concerned, we could tighten this. We could look at a judicial review instead of an ordinary review by psychiatrists only, as long as the judge who is reviewing is someone who is in fact learned in the point of mental illness and in how mental offenders are treated and in the treatment facilities of mental offenders. That's something we could live with. But I think we do not want people to be sent into the federal prison. And what you will do is when you demand that they have 3 years, a lot of people will not claim NCR, will go into federal prisons. That'll be a problem. The other thing is that there are people currently in the system who may have been rehabilitated and are ready for community rehabilitation and are ready to go back out into the system. This retroactivity in the bill will force them to stay for a further 3 years within the system. And I don't know if this meets a charter challenge, Mr. Speaker. I don't know if anyone looked at the constitutionality of that kind of mandatory incarceration of a person for 3 years, regardless of whether they're ready to go out or not, and regardless of whether people have said that they are ready to leave. So I think we wanted to look at this bill. It doesn't have charter scrutiny. There are no prevention components in this bill. There is no early diagnosis of mental illness in this bill. There are no community, institution, and support systems in this bill. And we heard very clearly, Mr. Speaker, that Mr. Howard Sapers, who is a correctional investigator, had this to say: "My concern is that we may see an increased number of offenders going into penitentiaries who have known significant diagnosed mental illness, including major psychosis, and the concerns around the capacity of the correctional service to deal with that is in fact a problem." So, Mr. Speaker, we would like to look at something else. In fact, my colleague, the honourable member from Montreal, went out and had a bill when he was Justice Minister in our government, and it was an excellent bill. In fact, the current Minister of Public Safety said he thought it was a great bill. So why don't we look at that bill again? Why don't we bring that bill in instead of something here that will do more harm than good and re-stigmatize the mentally ill? Thank you very much, Mr. Speaker.
Questions and comments? Questions et commentaires? The honourable member for Vaudreuil-Soulanges.
Thank you, Mr. Speaker. I'm not aware of the member for Mount Royal's bill, but what I heard is that the Liberals are arguing for the status quo in this current system. So my question for the honourable member from Vancouver is, when you see a victim like Isabelle Gaston, who says she's crying about injustice, she is called for changes in the system, even though I'm investing myself in changing the justice system right now. If it doesn't change, if ministers, deputy ministers, the law societies and the medical association don't do something, we'll continue to have injustice like this. What answer would she give Ms. Gaston when she argues that we should keep the system as is?
Thank you very much, Mr. Speaker. I guess the honourable member wasn't really listening to my speech, because we did not argue for the status quo at all. We suggested that it was important to look at ways in which we can enhance public security, in which we can ensure that the anxiety of the public is brought down, and one of those would be to look at a judicial review instead of the review that currently is going on. We also suggested that custodial community rehabilitation, in fact, every time a rehabilitated person is put into the community, that there's a custodian for a particular period of time until one is absolutely assured, and the psychiatrist, that that person is ready to be out on their own. We have agreed with the victims' problems. We think that a judicial inquiry on a judicial review should actually look at victims' impact statements. We're in agreement with some of the things that support victims. We're not seeking status quo at all. So I would ask the member to try and listen in future. Thank you.
Questions and comments? The Honourable Minister of Natural Resources.
Mr. Speaker, I'd like to cite a few statistics relating to recidivism and then make a general point about stigmatization. And I think it's very important that when we talk about what the risk to the public is, we try to get as close as we can to the facts. 27.3% of not criminally responsible accused have a past finding of NCR. 38.1% of NCR accused of a sexual offense had at least one prior NCR finding. 27.7% of NCR accused of attempted murder had at least one prior NCR finding, and 19% of NCR accused of murder or homicide had at least one prior NCR finding. I think those facts have to be brought into the analytical picture so that we get a more objective understanding of what is in fact going on. Few individuals, as the member opposite.
Other members still have comments and questions. We have about a 5-minute period, so we'd like to keep it to around 1 minute. The Honourable Member for Vancouver Centre.
Well, Mr. Speaker, I have absolutely no idea where the honourable member is getting his statistics from, but we got our statistics from the source. The Mental Health Commission of Canada, the Canadian Psychiatric Association, and all of the mental health groups that have collected this data over all of the years. The Canadian Bar Association also has these kinds of statistics here. But I think if you want to talk about one prior, and you're talking about 0.2% of the prison of people who have in the criminal system, and you're talking about 0.02 of those people who have committed violent acts, I think, you know, the member should get his facts correct and look at the numbers in which he's dealing. When you're dealing with such tiny numbers, it really doesn't make any sense for him to quote the...
Questions and comments. The honourable member for St. Paul's.
Mr. Speaker, and I thank the member for her remarks and also for the member from Toronto Centre. I think that, again, as the member from Toronto Centre explained about the hot button issue, and I think as the member from Vancouver Centre said that that this is an issue of public safety, that if lawyers are advising the accused to not actually plead NCR and actually will end up out on the streets earlier and with a greater recidivism rate. Could the member explain really what it means to be NCR and what it means to have a treatable condition that very quickly can be remedied, and that within 1 year this could be a very different person than the person who committed the crime?
The honourable member for Vancouver Centre, a short response, please.
Thank you very much, Mr. Speaker. Absolutely, because you have to understand the nature of mental illness. You have to understand that it is a mental illness. It's not simply a disorder, as I've been hearing it referred to here. It is a mental illness, and that many people who commit violent crimes, who have a mental illness, are not aware that they have a mental illness. They suddenly have a schizophrenic episode, or they suddenly have a manic depressive episode that they've never had before. And they could have this when they're 30. And we know that these are treatable people, and that my colleague is right. Within a year, with good treatment, these people could be ready, and many of them are absolutely appalled when they are aware of the criminal act that they committed. They are appalled at the fact that they did such a thing, and many of them become high.
Order. Order. Yeah, the time has expired for this round of questions and comments. Just to let all honourable members know, we have passed the 5-hour mark in terms of the time since the first round of speeches on this particular stage of the bill. So from this point forward, all interventions will be 10-minute speeches followed by a 5-minute period for questions and comments. Resuming debate, the honourable member for Etobicoke Lakeshore.
Thank you, Mr. Speaker. I'm pleased to participate in the second reading debate in support of Bill C54, the Not Criminally Responsible Reform Act. This bill will ensure that the mental disorder regime found in the Criminal Code and the National Defence Act achieves its objective of protecting the Canadian public by addressing a small but nonetheless significant segment of the cases that come before our country's courts, those in which a person is found to be not criminally responsible on account of mental disorder, otherwise known as NCR, for his or her actions. In my remarks today, Mr. Speaker, I'd like to explain why I think Bill C-54 is a targeted measure that will advance protection of the public while upholding the fundamental principle that a person found NCR for an offence must be treated differently than an offender who is convicted of a criminal offence. Before I address the particular reforms that are contained in this bill, I believe that it is critical to state up front what this proposal is not about. In particular, this bill is absolutely not about seeking to punish persons found NCR. In Canada's system of criminal justice, we draw a distinction between, on the one hand, individuals who possess the requisite capacity and intent to know that their conduct was wrong, and on the other hand, those individuals who are so mentally ill that their illness prevents them from appreciating the basic tenets of moral culpability that allow them to safely function in our society. The verdict of NCR is the means through which our justice system mutually recognizes the fact that harmful conduct was committed, which has real consequences for the victims and society more broadly, and the reality that the individual who committed that conduct suffers from a mental disorder. It is for this reason that Bill C-54 maintains the distinction between those found not criminally responsible and those who are convicted. The mental disordered regime in the Criminal Code and National Defence Act creates a separate process that aims to determine the risk that the person poses to society and decides how to best mitigate that risk in all of the surrounding circumstances. However, Mr. Speaker, Canadians agree that one key consideration that is common to persons found not criminally responsible and to those who are found guilty is the protection of the public. The Supreme Court of Canada has rightfully recognized in its 2010 decision in Arver v. Conway that public safety is paramount. As a result, sometimes there is simply no other choice than to restrict the liberty of an individual who is very ill in order to mitigate the risk that his or her unique illness poses to others. Society expects no less of the government, Mr. Speaker, to ensure that the risks to the safety of our communities are meaningfully addressed, irrespective of their source. And that is what Bill C54 aims to achieve, a tailored and fair procedure to confront the real and significant risks posed by a small number of ill persons who commit criminal conduct. Bill C54 achieves its objective by establishing a new tool for Crown prosecutors that mitigates the risk posed by a small subset of the accused who are found NCR. That tool is the discretionary option for the Crown to apply to seek a determination that a particular individual is a, quote, high-risk accused. The high-risk designation made by the court is to be based on all of the relevant circumstances and evidence relating to that individual's particular illness, treatment, and behavior. In assessing the merits of Bill C54, it is important to situate this high-risk designation in its proper context. It is not a mandatory procedure, and it will not be used in each and every case of where a person is found not criminally responsible. This is because the risk posed by a person who is seriously ill depends on the unique facts of his or her case. This high-risk designation would only be available in cases involving serious personal injury offenses, where a court is satisfied that there is a substantial likelihood that the accused will use violence that could endanger the life or safety of another person, or where the court is of the opinion that the acts that constitute the offence were of such a brutal nature as to indicate a risk of grave physical or psychological harm to another person. I am confident that Crown prosecutors will exercise their discretion to bring such an application in instances where the public interest in keeping our community safe is present. A further feature of the process is that the threshold in the proposed test for the high-risk designation is higher than the threshold in the standard test under the current law for continuing to supervise the mentally disordered accused. And the burden of meeting this threshold is on the Crown, not the accused. Bill C54, Mr. Speaker, also recognizes that the risk to public safety of an individual can change over time. High-risk NCR accused would still be entitled to regular reviews to determine their progress. The starting point is for them to receive annual reviews, but this review period could be extended up to 3 years if the accused and the Crown consent. The period can also be increased at the discretion of the review board if they are satisfied that the high-risk NCR accused person's condition is unlikely to improve in the following 3 years. This is an incremental change from the current law, which already allows for extending the review period from 1 year to 2 years. This is a sensible approach that properly recognizes that each and every illness is unique, and particularly such grave conditions that so profoundly affect the behavior of individuals. Mr. Speaker, when seen through this perspective, it becomes abundantly clear that Bill C54 is a just and reasonable approach. I am sure that we all recognize that all serious offences are tragedies for the victims as well as for our communities. Bill C54 will preserve confidence in the administration of justice, protect the safety of the public, and uphold fair treatment of ill persons who are found not criminally responsible. It is a targeted bill that I am proud to stand in support of. Thank you, Mr. Speaker.
Questions and comments? Question commentaire. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank the honourable member for Etobicoke. I'd like to pick up on some of the points that have been made. It's hard when battling statistics are raised in debates and people are left to wonder what is the actual state of the evidence here. I'm persuaded by the various briefs by the Canadian Bar Association and scientists and people who have dedicated their life's work to this area, such as McGill University psychiatrists and others, that really the rate of recidivism for people who've actually been found not criminally responsible is extremely small. So I was baffled by the statistics used earlier in the debate by the Minister of Natural Resources. I wish I could have gotten the question to him, but the best statistics I can find say that only 7.3% of not criminally responsibly designated NCR accused falling into that category actually return to commit a violent offense within the next 3 years. So it's, the experts in this area are saying this is not an area where we need to fix the problem. They aren't saying there isn't a problem, and they are saying that where we really need to focus resources is on adequate treatment and identification of people with mental health issues to ensure that both they and society are protected.
The honourable member for Etobicoke Lakeshore.
Thank you, Mr. Speaker, and I thank the member for her question. The Minister of Natural Resources cited a few recidivism statistics, and whether it's 27.3% of NCR accused that had past findings of NCR, or it's 4%, or it's 7% that the member states. What's important in this legislation is that prosecutors have some additional tools at their disposal, and we leave it to some people with some expertise to decide where and when is the protection of society is paramount. I think we can all agree that all tragedies, whether it's 4 out of 100 people experiencing recidivism, or if it's 25, these are terrible tragedies, and we need to do everything we can as a society and as a justice system to make sure that the experts, the prosecutors who deal with these kinds of things, using the advice of mental health experts, can decide whether these kinds of tools need to be applied in each individual case. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Burnaby, New Westminster.
Well, thank you very much, Mr. Speaker. And I've been, as my colleagues in the NDP caucus have been doing throughout this debate this evening, asking a series of questions that seem to come with no response. We're supportive of the legislation. We're in support of the principle, Mr. Speaker. We've said that a number of times, but we do need answers to these important questions that we've been asking. One of them is that there appears to have not been any real discussions in any meaningful way with the provinces. And given the fact that this government has moved to cut back on healthcare funding, as we know, following next year, Mr. Speaker, so what we're seeing is a cut in transfers to provinces. This was something that was done unilaterally the year before last. The concern is that what this government is doing is putting forward legislation without providing the financial supports to ensure that the legislation can actually be put into effect. So can the member comment on the cutbacks that this government is effecting in healthcare transfers?
The honourable member for Etobicoke Lakeshore.
Yeah, thank you, Mr. Speaker. You know, no government has done more to support the provinces when it comes to transfers. Just to cite some numbers, we're transferring currently to the provinces $62 billion a year, and that's up 50% since 2006. So when it comes to provinces managing their budgets, we're really providing them with the resources they need through the strong economy that we have. I do want to thank the member for his question, though, because I do recognize that the NDP has decided to support this bill and advance it through second reading. And it's because I think they recognize that there's a lot of consultation that there's a lot of balance here. It certainly deserves to go to committee. And just, to cite another voice on this, the Globe and Mail from my city of Toronto said the Conservative government's proposed new law aimed at making sure severely mentally ill offenders are not set free while they're still dangerous is a fair and measured response to the problem of Vince Lee, Alan Schonburn, and Guy Turcotte. I mean, that's one voice. There's many other voices. People have weighed in, mental health experts, criminal law experts have weighed in. All the provinces and territories were consulted also on this bill, and that's why we think it's fair and balanced and deserves to go to third reading. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Calgary Centre North.
Well, thank you, Mr. Speaker. And just before I begin my remarks tonight, when we gather in this place here late at night, away from our families, sometimes it behooves us to take a moment to remember them. And with that, I beg the indulgence of the House to wish my stepfather, Randy Field, a very happy 60th birthday. And I'm so sorry I'm missing your birthday tonight. What's very interesting about this bill is the stage that it's at in debate here in the House. And we're debating as a group of colleagues whether or not it has merit to move to the committee stage of review. And I've spoken in this House a few times now about the difference between the how and the why of an issue. And I think we need to set the record straight a little bit on the why of looking at this legislation first. I had some notes prepared tonight, and I think I want to start off by actually looking at my Twitter feed, and I have someone named Dave Texera talking about the Darcy Clark family and thanking government members as well as my colleagues opposite for at least giving this legislation a chance and going to committee. Because the why of this committee, the why of this bill is important. And I've heard colleagues opposite talk about, you know, rehabilitation rates and times and you know, the rights of the offender. And we do, as legislators, have an obligation to examine the rights of all individuals in this country. But for this legislation, the why is looking at victims of crime who are victimized, who day after day wonder if they are going to be threatened again, if living in a state of fear. And these are real people with real questions as to how they're going to be protected by us who stand here in this place. I just don't accept the premise of some of my colleagues' arguments, and I'm quite shocked to hear them, frankly, that somehow this isn't an issue. What I had hoped to hear tonight, Mr. Speaker, was to acknowledge that the why of this issue is fundamentally important and worthy of study. That's why I'm very, very glad to hear my colleagues opposite at least support, in the NDP, at least support moving this to the committee stage, because the why here is so vitally important that we look at as legislators. I'll speak very briefly to the technical aspects of the bill. There's three components that we on the government side see it addressing. First of all, in enhancing victims' rights, the legislation will enhance the safety of victims by ensuring that they are specifically considered when decisions are being made about accused persons found NCR, not criminally responsible, ensuring that they are notified when an NCR accused is discharged, and allowing non-communication order between an NCR accused and the victim. The second component is to put public safety first. The legislation would explicitly set out that public safety is the paramount consideration in the decision-making process related to accused persons found to be NCR. And of course, the last component is to create a high-risk designation. The legislation would create new designation to provide the public from, protect the public, from high-risk NCR accused. Upon being designated by a court as a high-risk, an NCR accused must be held in custody and cannot be considered for release by a review board until their designation is revoked by a court. Now, some of the questions which have come up tonight are very valid, and they should be looked at committee stage. But specifically on the question of consultation, absolutely we want to look and consult with affected stakeholder groups on any legislation. That's our job as legislators. That's what we do in committee stage. But I think it's worth noting the amount of discussion that this legislation has generated in federal, provincial, and territorial discussions between public safety ministers and ministers of justice. We have heard from our provincial and territorial counterparts that this is something that's important. Now, why is that important? It's because for such a long time we have not addressed the rights of victims such as Ms. Darcy Clark and her family. And I think that for anyone who's sitting at home watching this debate, you would be hard-pressed to find someone who would say that this is not worthy of at least moving to committee stage, Mr. Speaker. Some of the other points that I wanted to make were with regard to some of the content of the bill. So, for example, that the bill proposes to expand the notice requirement so that victims would be made aware when a mentally disordered accused person is to be discharged into the community. I think that this is something that's quite reasonable. I think that if you took this to the Canadian public, if you took this to a constituent, notifying a victim of when someone who has committed a crime, often atrocious, against them or their family, notifying when they are going into the community, that is something I think most people would find reasonable. I, of course, would love to hear the results of the committee phase hearings on this, Mr. Speaker, but I think that this is something that most Canadians would say is fundamentally reasonable. The approach of the bill also reflects the reality that not all victims want to participate in some of the hearings around the NCR designation. And nor do victims want to be kept abreast of when and if an NCR accused is to be discharged. This is understandable because people who have been victimized, I'm guessing, probably don't want to be re-traumatized over and over again. An automatic notice provision, as provided in this bill, would cause them to be, would be alleviated, may cause them to be further traumatized by forcing them to relive the incident. That requirement that victims must request notification is therefore intended to protect those victims who do not wish to be notified. Again, going back to the second element of Bill C54, it's related to victims, specifically to their safety. Currently, the mental disorder regime requires the review boards to consider on an annual basis whether or not an NCR accused still represents a significant threat to public safety. However, at present, there is no requirement that the review board take into account the safety of the victim when they conduct their analysis. And, Mr. Speaker, there is no requirement that the review board take into account the safety of the victim when they conduct their analysis. I think that's something, again, that's perfectly reasonable to take into consideration. Our criminal justice system, yes, we have to look at the balance between the individual and society, as some of my colleagues have talked about. But in this case, to take into account the safety of the victim, that's something, again, that I find reasonable, and I'm pretty certain if I took it back to my constituents, Mr. Speaker, that they would find reasonable as well. What does this bill do to change this? It clarifies that significant threat to the safety of the public includes the safety of the victim. And this would ensure that when a review board is considering whether or not an NCR accused person continues to pose a significant threat to the safety of the public, they would be required to specifically consider the safety of the victim. This element will provide some much-needed assurance for victims who are concerned that their interests are not being adequately considered by the review boards. And in that, giving victims a little bit more assurance that their rights are at least being considered by our review boards, I think is also something that is perfectly reasonable and should also be used to support the passage of this bill into second reading, or into committee stage, Mr. Speaker. This bill also proposes that the review board considers whether or not it's in the victim's interest to make an order of non-communication between an NCR accused person and the victim, and for an order that the accused person not attend at a specified place. Although it's currently possible for review boards to make these orders, the proposals in Bill C54 would require the review board to turn their mind to the issue in every case. Again, practical solutions that could be considered to address the safety and the peace of mind of a victim, Mr. Speaker. The goal of these orders would be to provide increased security victims, much-needed peace of mind, and ensuring that an NCR accused will not be permitted to have any contact with them. They may, in fact, be ordered to stay away from certain places, such as their place of employment or their children's school. You know, Mr. Speaker, when we stand here in this place, we have to consider all sides of an issue, and I know that there are very many views of how we can address the why of this concern, Mr. Speaker, but to just oppose this without even giving pause to the thought of people who have been victimized, and we can cite recidivism rates, we can cite rates all we want, but my question to my colleagues opposite is this: what percentage is acceptable? And what percentage requires us to abdicate our duty to look at those who may be effective in a situation like this? That's why I'm certainly supporting this bill at passage to committee stage. I know that the Justice Committee will conduct further diligence, will bring in witnesses to review this bill. But, Mr. Speaker, I certainly hope, and I ask with great honesty my colleagues in the Liberal Party to at least consider voting for this at second reading due to the why, and to really consider asking themselves when they go home at night, what percentage is acceptable?
Questions and comments? The honourable member for Esquimalt, Wanda Fuca.
Thank you very much, Mr. Speaker, and I thank the honourable member for her comments, and I really appreciate the emphasis she gave to improvements for victims that are contained in this legislation, because that's a large part of why we in the New Democratic Party are in support of this in principle. I do have a concern, and that is the use of time allocation, again, on this bill. One of the things that was brought up by the chair of the Canadian Mental Health Commission, Louise Bradley, when she said we encourage all legislators and stakeholders to work together to ensure Bill C54 strikes the right balance to encourage treatment and to avoid the unnecessary stigmatization of Canadians who live with mental illness. And so I guess my concern is when we get to committee that we do hear from those who have those concerns and see if there are changes that need to be made in this legislation that will help mitigate those concerns. Because I do think the legislation is fundamentally sound. So I'd like to hear some assurance on the other side that we will hear those voices at committee.
Parliamentary Secretary to the Minister of the Environment.
Well, thank you, Mr. Speaker, and I thank my colleague for his very respectful comment on this issue. I'll answer the question in two parts. First of all, it was our government that actually established the Mental Health Commission, I believe. So we do have an emphasis on this issue. And as someone who has a family who is affected by mental health issues, I'm quite cognizant of the effect that these particular disorders have on, and illnesses have on, family and people around them. Certainly, we need to be cognizant of ensuring that we are supporting those with mental health services, not only in this, or mental health concerns, not only in this context, but also in the greater healthcare provision. I would certainly support, Mr. Speaker, a fulsome review of this at committee, making sure that we have the best legislation possible. And I do respect my colleague for citing that he will support this bill's passage to the committee stage.
Some comments. The Honourable Member for Kootenay, Columbia.
Thank you very much, Mr. Speaker, and I'd like to thank the Parliamentary Secretary for her speech. It was of interest when the member from the Liberal Party had spoken about the not criminally responsible and their lawyer telling them that they could go through the normal process of court and probably get out earlier. That would probably indicate to me that you're not criminally responsible from that perspective, because you would understand that you could go through the normal court process, which leads to my question, Mr. Speaker. Could the Parliamentary Secretary explain to the Canadian public with regards to the reforms and the annual review period for 3 years, and who does that actually affect with regards to the 3-year review?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Well, Mr. Speaker, to answer my colleague's question, I'll go back to the start of my speech, and that is the substance, or the why we are looking at this legislation. And the reason why this legislation has been proposed, it is to be respectful of the rights of victims, as well as to provide them with additional peace of mind and security that their safety, their mental health as well, given the recovery of a traumatic situation, we have to be cognizant of their mental health as well. That is what this bill proposes to do, Mr. Speaker. So I can only, Mr. Speaker, I can't speak on behalf of some of these victims because I've never had something like this happen to me, but I can only imagine. And that's why we stand here today in support of this legislation.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I also thank the Honourable Parliamentary Secretary for her presentation. I'm afraid that I'm not yet at the place where I think that this legislation actually does more good than harm. I'm trying to debate that in my own mind, looking at the evidence and the expertise that comes forward. One of the experts to whom I referred earlier, Dr. Ann Crocker, Professor of Psychiatry at McGill University, put the statistics this way, so we really can focus on this, that of all of those considered not criminally responsible offenders in BC, Ontario, and Quebec, less than 10% of that group were responsible for violent crimes. Within that group, now we're getting down to very small numbers, less than 15% went on to reoffend. So I think what happens is we have some very high-profile, extremely upsetting cases. I mean, they're devastating when you have the kind of cases, I don't need to mention the names, we all have them on our mind as we debate this legislation. But this legislation would do nothing to prevent somebody with a mental health issue who had no previous record from committing the offense. Surely, when we have experts in mental health, experts in criminal justice system, experts are saying the current system is not letting us down in terms of handling NCR cases and avoiding recidivism. Where we're being let down is that we're not putting in place the structures to support those people so that mental health issues can be streamed into the health system and not into the criminal justice system.
The Honourable Member for Calgary Centre North.
I'm glad that my colleague opposite has admitted that she is looking at this bill and trying to decide whether it should pass to the committee stage. And I would implore her to at least get it to the committee stage for a few reasons. First of all, Yes, we can talk about recidivism, absolutely. But the point I'm trying to make here today is that when we talk about percentages of reoccurrence, we haven't acknowledged the fact that, yes, there are high-profile cases, and yes, in fact, the lack of legislation that we have in this area can lead to distress, deep distress, a deep sense of non-peace in the minds of victims. I think for that matter, it's very important that we at least examine the merits of this bill at committee stage. I fundamentally feel that as legislators here, we cannot fail even one person, Mr. Speaker, in this regard and in this context. That's why it's so important.
Resuming debate, the honourable member for Surrey North.
Thank you, Mr. Speaker. I'm honored to speak about Bill C54 on behalf of my constituents from Surrey North. Last week, in the debates around Bill C489, I spoke about the impact that proposed legislation can have on victim rights. And today I will speak again about it, but in the context of Bill C54, which is an act to amend Criminal Code and the National Defence Act. This bill will modify the legislative framework in the Criminal Code and National Defence Act that applies to trials and results in alleged offender being deemed not criminally responsible on account of mental disorder. This bill presents a timely and very important discussion on mental health issues, victim rights, and public safety. It is clear in the wake of several recent highly publicized cases, we need to examine the current legal instruments to ensure that adequate protection is being awarded to the public and that victim needs, particularly in relation to the psychological healing and safety, are being considered with utmost priority. However, as with any discussion in this House, we must carefully weigh the balance between perspectives. Many mental health professionals have already voiced their concerns about the effect that this bill will have on people with mental health issues. Those concerns are legitimate and deserve the chance to be explored in depth. This is a fragile issue for victims, families, and communities, and we must be careful that we protect the interests of all Canadians in our deliberations. Mr. Speaker, Bill C54 proposes to amend the current legislative mental disorder regime by putting public safety first, creating a high-risk designation for certain offenders, and by enhancing victims' involvement in the justice process. Mr. Speaker, obviously as members of Parliament and legislative decision makers, we need to place Canadian interest first and security as a paramount in all our evaluations and resolutions. From this perspective, the public safety first focus that Bill C54 proposes should be reflective of the majority of Canadian legislation, and we should welcome its relevance to the common good. However, this must be met with balance. The concerns of mental health professionals are in the bill C54 might create the concerns of mental health professionals are that Bill C54 might create mass panic, resulting in increased prejudice and decreased understanding about mental health illness. We need to be cautious that we are not perpetuating an unwarranted stereotype that all people with mental health illness have potential for violence. Furthermore, Bill C54 proposes that some offenders deemed not criminally responsible may be categorized as high risk, where persons that have been involved in serious injury offense, and there is a considerable likelihood for further violence that would endanger the public. Mr. Speaker, high-risk offenders should be subject to an increased amount of time between review, board hearings, 36 months instead of the 12 months that it is currently at. They would also have escorted community visits, and in some cases, community visits would be eliminated. There's a concern that some defense attorneys may avoid seeking a mental illness defense because of the limits on this designation, limiting the treatment and resources available to their clients, and potentially exposing their clients to harm in traditional detention facilities. Bill C-54 also enhances victims' involvement in the criminal code mental disorder regime. They will be notified upon request when the accused is discharged. They will provide non-communication orders between the accused and the victim. They will ensure that the safety of the victim is paramount to the judicial decision-making process. Mr. Speaker, this element of Bill C54 could be particularly important for the healing process of the victims and their families, and it may be essential to the development of a safety response strategy. Obviously, I have reservations about the proposals in this bill, but I think we must equally weight the balance of arguments of any proposal that comes across this House floor, Mr. Speaker. Specifically, in the discussion around Bill C54, we need to be conscious of the fact that only a small number of cases are found not criminally responsible on account of mental disorder under the criminal code. Furthermore, the rate of a reoffending for accused found not criminally responsible due to mental disorder is only 2.5% to 7.5% compared to federal offenders in the regular justice system, where reoffending rates are 45% to 44%. With that being said, Mr. Speaker, I think that our utmost focus in this debate must be public safety, as well as justice and support for victims. We need to explore Bill C54 in detail to ensure that it offers effective solutions for victims and adequate protection for public. At the same time, we need to be respectful of the challenges that face people with mental health issues. We must keep the focus on prevention, treatment, and support resources. I will be supporting Bill C54 so that it can be studied extensively. I'm looking forward to the opportunity to hear from mental health professionals, legal professionals, victims and rights, and families of victims to ensure that we are making informed decisions that will be valuable to Canadians and have their best interests at core. And I would encourage my Conservative colleagues to listen to those professionals, not only listen to those professionals, but also make the appropriate amendments that are needed to make this bill even better than what it is in the current state. I know that the Conservatives hesitate to add amendments, as we've seen over the last year or 2 years, where 99% of the amendments that are introduced by the NDP, my NDP colleagues, they have been rejected by the sitting government. So I would encourage them to listen to the frontline workers, listen to people that are providing these services, listen to, Mr. Speaker, I was reading, looking at the website today, the correctional officer, investigation officer, Howard Saper, pointed that out today in the media, that he has some concerns. So I'm hoping that they will listen to the concerns of not only government workers, but also people in the front lines, so that we can make this bill a better further enhance it. It is important to note that in its current form, Bill C54 will rest all financial obligations with the provinces. The federal government should ensure that adequate financial support is provided so that provinces have financial capacity to carry out these responsibilities. Bill C54 presents an opportunity for us to review how underfunded mental health services are in Canada. In fact, recently I've spoken to social workers, social service providers in my own riding who have expressed their frustrations at not being able to provide adequate mental health resources to their clients due to funding challenges. Mr. Speaker, we must also ensure that adequate funding is provided to mental health services, as their work is invaluable to prevention, treatment, and advocacy for accused offender deemed not criminally responsible due to mental disorder. Mr. Speaker, in concluding, I hope the government will seriously consider the amendments proposed by the opposition parties, as well as the advice and stories of mental health professionals, legal professionals, victims' family, and rights groups. As policymakers, we must be open to institutional changes that are productive, effective. We cannot present grandiose ideas with little to back it up with. We must ensure that potential legislation that we debate is critically explored and will present effective remedies for its intended focus. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Winnipeg North.
Thank you, Mr. Speaker. And I've had the opportunity to talk about the whole idea of prevention, and would love to see a government more focused on prevention. But have this bill before us, and I understand that the New Democrats will, in fact, be supporting its passage into to the committee stage. The question I have is in regards to your comments in regards to the need for changes to the current legislation or for amendments. And I anticipate that the New Democrats will be bringing forward amendments. Are they saying that if these amendments do not pass, then they will be supporting or not support the bill? Is there tentative support in second reading subject to amendments being passed from the Democratic caucus?
The honourable member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, it doesn't amaze me. You know, every time the Liberals get up, they always talk about what they want to do. However, when they get in government, they exactly do nothing. They do basically what the Conservatives do, which is nothing most of the times. So my answer to this question, to this honourable member's question is, I don't have a crystal ball. On principle, we agree with this bill going into committee, and we are requesting and we're hoping that Conservatives will listen to the advice that's provided in the community by experts, by community workers, and then they will make some of those changes to make this bill much, much better than what it is already.
Questions and comments. The honourable member for Burnaby, New Westminster.
Thank you very much, Mr. Speaker. I'd like to thank the member from Surrey North for his very eloquent speech tonight. He brings a lot of experience and knowledge to the justice sector, having worked for the Justice Institute in the Lower Mainland of British Columbia, and that was clear tonight, Mr. Speaker, from all that he said. The member from Surrey North has a great knowledge of these issues, and he was asking questions, Mr. Speaker, that other NDP members have been asking about how this government actually put together the legislation that we support and who they are going to be consulting with. Another concern that we've been raising on this side of the House, Mr. Speaker, is that ultimately this will be downloaded on the provinces. And members of the Conservative Party have been saying that it's not true. They've been increasing health transfers. The Parliamentary Budget Officer says different, Mr. Speaker, that we're looking at 20% of healthcare funding for the provinces coming from federal government. That is going to fall to 18%, then 13%, then 11%, Mr. Speaker. So this is a matter of real concern. We're talking about victims, and yet the federal government, this government, is trying to cut back on services for health care, services for mental health, services to victims. Does that concern the member from Surrey North?
Honourable member for Surrey North.
Thank you, Mr. Speaker. I want to thank my honourable colleague from Burnaby, New Westminster, for his wonderful question there. Mr. Speaker, I've seen a trend from the Conservatives over the last 2 years that I've been here, and I've seen downloading of responsibility down to the provinces, downloading of cost down to the provinces. Of course, I'm very concerned with what the Conservatives have been doing over the last 2 years, and not only that, what they have done with our health care transfer fundings to the provinces, which has been going to be cut over the next few years. And on issues like mental health, we need preventative programs. We need programs that'll help our mentally ill. And clearly, the Conservatives are not supporting the services that are needed in our communities.
We have time for one other short question and response. The honourable member for Halifax.
Thank you, Mr. Speaker. So, this legislation proposes to, oh my goodness, look, I've lost track. It proposes to make it very explicit that the review boards need to take into account the role of public safety in their decision making. But when I go back to the criminal code and it talks about dispositions from a court or review board, it says that in fact the review board needs to take into consideration the need to protect the public from dangerous persons. So I don't understand even what this legislation does. How is this actually anything new? And where is the evidence that we actually needed to have another provision say take into account the public safety? So I don't know if my colleague will have any answers to this, but where's the evidence that this needs to be done, and how is this different?
Honourable member for Surrey North.
Thank you, Mr. Speaker, and I have similar questions to our honourable members across this floor, and we're hoping that they will provide those answers in committee. We've asked questions throughout this session earlier today, and we haven't got any satisfactory answers from the government side. So hopefully we will be getting answer to my honourable colleague's question in the committee stage, and hopefully the Conservatives will look at some of the amendments, some of the expert testimony that we'll hear in the committee, so that we can make a bill that's truly helping our victims and also addressing the needs of the mentally ill.
Resuming debate, the honourable member for Selkirk Interlake.
Thank you, Mr. Speaker, and it is indeed a pleasure to be able to rise tonight and speak to Bill C54. Canadians expect that their justice system will keep them safe from high-risk individuals, and that's why our government has introduced Bill C54, the Not Criminally Responsible Reform Act. It is paramount that victims' rights and public safety are balanced off with the decisions taken for high-risk patients who are accused of being not criminally responsible for their actions. Our government's intention is to strike a better balance between the need to protect society against those who pose a significant threat to the public and the need to treat the mentally disordered accused appropriately. Our government has always put the victims first, and we always will. Mr. Speaker, the timing of this debate, unfortunately, is late. Just last week in Manitoba, the Manitoba Criminal Code Review Board made a decision that I was extremely disappointed in granting increased community access for Mr. Vince Lee. Now, as most of us remember, Vince Lee was on a Greyhound bus in Manitoba, just outside of Port Giles Prairie, on July 30th, 2008, when all of a sudden he started stabbing a young carnival worker by the name of Tim McLean. As the bus stopped and horrified passengers fled, Mr. Lee went on to cut up Mr. McLean's body and ate parts of it. Vince Lee has told a mental health advocate that he heard voices, including the voice of God, telling him that Mr. McLean was an alien who he needed to destroy. Vince Lee was not found criminally responsible and was sent to the Selkirk Mental Health Center in my riding. Now, it was incredibly disappointing to see the decision reached, because that decision did not put the victims' rights first. It definitely did not put public safety first, and I'm going to speak to that in more detail. As everyone knows from tonight's speeches, that the Not Criminally Responsible Reform Act, which we introduced on February 8th, does three main things. First of all, it's going to enhance victims' rights, and that includes enhancing the safety of the victims by ensuring that they are specifically considered when decisions are being made about accused persons found not criminally responsible. I can tell you that Carol D. DeLay, who is the mother of Tim McLean, said in the Winnipeg Free Press on Monday that I don't feel particularly safe or comfortable with Vince Lee having these outings. I have made the assumption before all this happened that we all have basic human rights. So how come Timothy's aren't being considered here and only Vince Lee's are? End of quote by Carol. She is concerned that now that he has free and open access on the grounds at the Selkirk Mental Health Center, as well as escorted leave into Selkirk, Winnipeg, Lockport, and the surrounding beautiful beaches on the south basin of Lake Winnipeg, that she feels that she may come into contact with him because she doesn't know where he's going. And that's why it's important that there needs to be non-communications ordered between an NCR accused and the victim, as well as notifying victims when they're not criminally responsible, like Mr. Lee, is discharged, so that they can come and make plans as to where they're going to be in the community that day and avoid the happenstance of running into the individual who has harmed their loved one. So it is important that we put victims' rights first, because in this decision that was just made in Winnipeg by the Manitoba Criminal Code Review Board did not at all consider the victims' rights, the family of Tim McLean. Both Tim's sister and mother read victim impact statements at that trial, and again, their considerations were thrown by the wayside. The second thing that this bill does is puts public safety first. And Bill C54 explicitly sets out that the public safety is the paramount consideration in the decision-making process relating to accused persons found not to be criminally responsible. This weekend at home, I heard from constituents across the riding, but especially in the city of Selkirk, about how concerned they are that Mr. Lee has free and open access to the grounds of the Selkirk Mental Health Centre, beautiful grounds, unfenced. Right across the street is a new public library that's going up. Just down the street, Walmart, Canadian Tire, Home Hardware. There's all sorts of activity happening around the mental health center, and he has the ability to roam those grounds and, without being monitored, easily walk off the grounds. And so the public are extremely concerned. And I can also tell you, it is not at all comforting to people in the public to run into Mr. Vince Lee when he is being escorted in the community. Because even though that he will have a healthcare worker with him, as well as a security guard, it is still very disconcerting to be seeing Mr. Lee walk past the front of their home or be in a shopping mall and bump into him. Even though, you know, he has escorted leave, I can tell you whenever I run across a murderer that is under the control and oversight of a security officer, I don't feel any more safe knowing that that security guard is there. In fact, it is more troubling to see that level of security required for an individual to be constrained while they're out in public. The third thing that Bill C54 does is it creates a higher risk designation. It creates a new designation to protect the public from the high risk, not criminally responsible accused. Upon being designated by a court as a high risk offender, that person must be held in custody and cannot be considered for release by a review board until their designation is revoked by a court. There needs to be that higher judicial oversight that doesn't exist today with the review board process. And it still allows access to treatment for any not criminally responsible accused person, so that would not affect it, and it is also still in these proposed reforms. Now, I heard earlier, and you know, the concern that that this isn't warranted by the member from Halifax, and I can tell you that in my community, they want to see this bill go through as quickly as possible. In Mr. Lee's case, it's already too late, but we have a mental health center as one of the main health centers in Manitoba, is located in Selkirk, and they're concerned about who else may end up getting housed there that are going to be found not criminally responsible. I also heard from the member from Saanich Gulf Islands earlier, Mr. Speaker, that she goes, this is completely unwarranted. There's no need for it. I don't think we need to look at all the cases of why we need it, but I do want to draw to everyone's attention the situation of Andre Denny. Andre Denny was detained in Halifax at a secure hospital in early 2012 after a court ruled he was not criminally responsible for a charge of assault causing bodily harm. Under this act, he would be considered a high-risk offender. While he was diagnosed with schizophrenia when he was a teenager, and records show that he was agitated and argumentative and paranoid in hospital after the court verdict. So Denny was a problem patient. They adjusted his medication and his condition improved, and he was granted supervised outings in early February 2012, so just over a year ago. So what happened? Well, several weeks later, on a 1-hour pass, he failed to return to the hospital. And he is now charged with second-degree murder of the beating death of an activist, Raymond Tavel, who was killed after he tried to break up a fight between two men outside a bar. So I don't think we need to argue about the need. I don't think we need to talk about the conditions of individuals. We know, and I know in my life, people that I have in my life that are struggling with mood disorders, personality disorders, that medication doesn't always work. And sometimes medication can amplify the problem or create other violent tendencies. And because of that, Mr. Speaker, we have to err on the side of public safety. We have to consider the rights of the victims' families and the victims themselves so they don't have to endure the long, drawn-out hardship of having these people in their communities and knowing that their loved ones normally are never coming back because of a very violent act by those individuals who have definitely been found in the courts to have some form of mental health issue, but at the same time, a very horrific and heinous crime was caused, and they feel that there needs to be some justification for that individual to undergo the proper treatment under close supervision, putting victims' rights and public safety first.
Questions and comments. The Honourable Member for Hochelaga. Thank you, Mr. Speaker. I'd like to put this question to my colleague. Why is it that most of the time Conservative bills are punitive rather than preventative? If one really wants to emphasize victims, why not support bills like this with financial assistance for victims, for example?
Selkirk Interlake.
I can tell you, Mr. Speaker, and I can tell the member across the way that victims aren't looking for financial help. They aren't looking necessarily for increased punishment. What they're looking for is that their rights are respected, that they are put first and foremost in these decisions, and that the memories of their loved ones aren't being insulted like we just saw in Manitoba. So we want to ensure that we do find the balance, but we have to also look at the overall aspect that we aren't always putting as a paramount decision through the review board process, the paramount decision of victims' rights and public safety first and foremost. And if you talk to those who are impacted, yeah, they've had to go on long-term disability because of their own mental health after they lose a loved one. And our government has introduced a number of reforms to EI to help with that fact. But more importantly, they aren't looking for those types of supports as much as they're looking for to ensure that the public safety is put first and their loved one's memory is honored.
You're here. Questions and comments. The Honourable Member for Vegreville Wainwright.
Thank you very much, Mr. Speaker. Mr. Speaker, first of all, I want to say I really appreciate my colleague's presentation, but I was kind of shocked when I heard the member from Halifax ask a question earlier. Her question was, why is this needed? And yet we had the member in his presentation talk about Mr. Denny, who in fact is a perfect example, and that's right from the member's home riding of Halifax. A perfect example of exactly why this legislation is needed. And I wonder why that member can stand up and ask that question about why this is needed when a constituent of hers has killed again, and would be protected probably from a law like this. So I'd like to ask the member why the disconnect, if he wants to take a guess, in her reasoning on this whole issue.
The Honourable Member for Selkirk Interlake.
I want to thank my colleague for that question, Mr. Speaker. And I can tell you that I don't think anyone that was a friend of Raymond Tavel or anyone that knew. Yeah, I understand that, and so I'm just saying that you can't return that life. And if this bill was in place, it is very unlikely that Andre Denny could have done that heinous crime and that horrific second-degree murder of Mr. Tavel and all the good that he is doing in the gay community in Halifax. His family, his friends were devastated, and I think we all saw the media coverage of that. I know that all of us, it's always concerns us when somebody that is dealing with a mental health issue becomes this violent. But for those individuals, like Mr. Denny, we have to take the measures possible to confine them and protect the public so that these types of crimes don't happen.
We have time for one short question and response. The Honourable Member for Kings Hants.
Mr. Speaker, when I hear the dialogue here tonight and I hear Conservative members defending the memory of Raymond Tavel in Halifax, and I know that the member from Halifax has raised this issue in good faith in this House. Number one, you can't bring someone back. Number two, the Conservatives in this debate continue to demonize and stigmatize people with mental health issues, not to protect the public, but to pit one group of Canadians against another. And while I would ask the honourable member, where is his passion to defend the rights of gay and lesbian Canadians? And where was it during the debate on same-sex marriage? Now, while I thank him for his interest in these issues tonight, I would ask him to actually consider his long-term perspective and his party's long-term perspective on these issues, and not to use the memory of Raymond Tavel to try to take a position and defend a position that Raymond Tavel would find reprehensible.
Order. We are out of time. The honourable member for Selkirk Interlake, a short response, please.
Mr. Speaker, I don't find our debate here at all divisive. This is a commentary about wanting to improve a system, and I appreciate the work that Raymond Tavel did on behalf of the gay community. And I can also tell you that if you want to talk about divisive comments, what about the leader of the Liberal Party earlier this week talking about rights of one region of Canada versus the other? Let's pit East against West again and again, and this is what we're hearing coming from the Liberal end of this House.
Order. We're resuming debate. Reprise de débat.
The honourable member for Hochelaga. Mr. Speaker, thank you for allowing me to express myself on Bill C54. This bill amends the mental disorder regime in the Criminal Code and the National Defence Act to specify that the paramount consideration in the decision-making process is the safety of the public. It creates a mechanisms for certain persons found not criminally responsible on account of a mental disorder to be declared high-risk accused. It also ensures greater participation by victims. Allow me to reiterate the reasons why we must discuss this bill today. Recently, several highly publicized cases of very serious offenses had been committed where the accused was declared not criminally responsible, and this was put back on the table. In Quebec, we particularly heard about the Guy Turcotte affair, where a man killed his 2 young children. And this story had shocked the public, not only because the violence of the action, but the verdict. Even though he was certainly the one who committed this act, he was declared not criminally responsible. Our first concern is, of course, how it would be possible to better help the victims in such situations. And like many other cases, the Turcotte affair created doubt in the minds of many as to the efficiency of the current approach with respect to criminal responsibility, and is particularly necessary to restore public confidence in the administration of justice. According to his psychiatrist, the anger expressed by some sectors of the population, given the situation, is due to the lack of understanding of how the Mental Disorder Review Board operates. I'd like to make a few observations about the nature of the current process. First of all, we have to reassure the people listening to us that the mental disorder regime, as currently provided for in the Criminal Code, only applies to a very small percentage of accused persons. It's not as if all people charged had access to it. If the accused person cannot understand the nature of the trial or its consequences and cannot communicate with their lawyer on account of a mental disorder, the court may then find that the person is unfit to stand trial. Of course, if the person becomes able to stand trial later, the case will be heard before the courts. Another situation can happen during the trial. It can be established that the person did carry out the offense, but that mental disorders prevented them from judging the gravity of it. So a court can make a special verdict of lack of criminal responsibility. The person is thus not acquitted nor convicted. In a case where a person is declared unfit to stand trial or not criminally responsible because of a mental disorder, a provincial or territorial commission examines that person's situation and can make one of three decisions: absolute discharge if the person does not pose a significant threat to society, conditional discharge, or detention in custody in a hospital. Bill C54 seeks to amend the criminal code to specify certain provisions in the mental disorder regime. First of all, courts and provincial boards should make public safety the paramount consideration in their decision-making. Secondly, Bill C54 would amend the criminal code to allow for the possibility of declaring a person found not criminally responsible represents a high risk if he was accused of serious personal injury offense, or that there is a high likelihood that he will commit other violent acts or expose the public to danger. This type of accused could obtain neither conditional nor absolute discharge, which means they would be kept in custody in a hospital. Only a court could reverse that decision following a recommendation by the review board. The impact of finding an accused not criminally responsible and high risk would mean that it would prohibit that person from being in public without an escort, without authorization, and only in rare circumstances in accordance to sufficient conditions to ensure public safety. The review board could also decide to extend by 3 years the examination period for a high-risk person, whereas normally it would be 1 year. The bill also seeks to increase the safety of victims by allowing them to participate more in the process, by ensuring that they're informed on request when the accused is released, by providing for prohibited contact between the accused and the victim, and by making sure that the safety of victims is taken into account when decisions are made about an accused. Mr. Speaker, to sum up, the NDP agrees that we must protect public safety while respecting the rule of law and the Canadian Charter of Rights and Freedoms. We believe that these changes are desirable, but we have to make sure that they will allow us to treat the accused suffering from mental disorders effectively. In Canada, the total cost of criminal code offences is over $31 billion, according to an estimate by the Department of Justice. Of that total, almost half is absorbed directly by the victims. We're talking about over $14 billion a year. That's huge. That's what it costs for medical care, hospitalization, loss of income, absence from school, or lost or stolen property. In addition to direct victims, people in their entourage also can be affected. The cost for third parties is about $2.1 billion, and it's even more if you look at the intangible costs, such as lack of productivity over a lifetime, the cost of mental health problems, psychological effects on other family members, etc. We're talking about almost $70 billion. So in total, crime costs about $100 billion a year for Canadian taxpayers. We have to be careful here because these are estimates, but it gives us an idea of the impact of crime on all of society. I'd like to get back to the Guy Turcotte case because it's the most high-profile case, at least in Quebec. As I said, Mr. Turcotte was found not criminally responsible by the court that heard his case. The review board decided that he was free to leave the psychiatric hospital he was in, but that he had to respect certain conditions. That's also the opinion of the team of psychiatrists that followed up on him. He's no longer sick and no longer represents a danger for society. His former partner, Isabelle Gaston, is still continuing to try to make sure there are changes in the system, and I quote her: "Even though I have invested myself in changing the justice system, right now, if it doesn't change, if the ministers, the deputy ministers, the bar, and the College of Physicians and Surgeons do not change their way of doing things, we will continue to see injustices like this," unquote. In the NDP, we agree with this goal and the spirit of this bill. That's why we will vote for the bill in second reading so that it is considered in committee. But certain points should be clarified. For instance, right now, even though we agree, we wonder whether the proposed changes are not primarily cosmetic. Let me explain. The most significant change brought forth by C54 concerns the fact that the review boards will have to make public safety the preponderant factor in their decision, but they already consider public safety. So I'm wondering what fundamental difference this bill will make. Other legitimate questions deserve to be asked. Consultations, or at least some cooperation with mental health specialists and stakeholders in the current system, have they been done in order to make sure this is the best approach? Has the government provided for additional resources for the provinces and territory in order to take into account the new responsibilities of the review boards? I don't think so. Will additional measures be put in place in order to support victims? That's not what we're being told either. Nevertheless, on principle, the NDP and I are open to the proposed changes. We will support this bill in second reading in order to examine it further in committee. Thank you, Mr. Speaker.
Questions and comments. The Honourable Minister of State for Western Economic Diversification.
Thank you, Mr. Speaker. I wanted to get up this evening on behalf of a mum in my close to my hometown. It was a small town, not very far from where I live, and they were victimized. Their son was murdered brutally. The two young fellows that murdered her son, Rob Vicente, was shot twice in the head, and then he was taken, rolled out of the vehicle, shot in the head again, and then he was buried in the yard of one of the murderer's grandmother's home. The mum doesn't sleep. They really are having very, very difficult time with the murderers getting off on second-degree murder, and they are very worried in a small community that these young people will come back. What do we tell? How do we tell that mom that her story is not as important as what that all the things that happened to her are not quite what we want to hear. We want to hear, can there be can these young people who showed no remorse, they showed no remorse, Mr. Speaker, and the mom has to live with losing this son. And what do you tell the mom? What can I tell the mom that assures that these young men will never, ever get out of jail?
The Honourable Member for Hochelaga. Well, as I said at the beginning of my speech earlier, there are situations that are truly horrible, like that one. The public has lost confidence in the justice system because of that. And that's one of the reasons why we want to vote for this bill, despite the fact that we think there's already some protection against this kind of crime. But the other thing is that there are mothers like that who are victims. And that mom should get help. And as I said earlier, I asked the question twice. I asked the Conservatives, will assistance be provided to victims under this? No, there is none. So if we really want to help that mom, and I really think that there are points that you covered that are already in this bill. Questions and comments. The Honourable Member for Vaudreuil-Soulanges. Thank you, Mr. Speaker. My question is specifically about the point mentioned earlier. Given that spending in healthcare or transfers from the federal government to the provincial government are going down, is the member worried, given that the spending has declined and the provinces cannot meet the needs of the victims in the provinces? The Honourable Member for Hochelaga. Well, of course, with reduced budget, it'll be increasingly difficult to respond to the needs of victims. But the other thing is, some Conservatives said that they had consulted the provinces. When I asked them exactly what kind of consultation had been done, I didn't get an answer. And I'd really like to know. I still don't have an answer. I still don't know whether they consulted the provinces about the financial aspect of this. If the provinces were consulted, did they realize that there'd be this whole new set of measures they'd have to pay for and absorb? And did they agree with that? We have time for one very brief question. The Honourable Member, or the Honourable Minister of State for Western Diversification.
Thank you, Mr. Speaker, and thank you for the answer to my last question. But that was my point. It wasn't the resources. They did get help. She went to Edmonton. She joined self-help groups. But what she wanted was to see first-degree murder applied to these young people. She wants to make sure they never get out. They're going to get out in 15 years. They will have a parole review. She wants not to have them out and released. All the self-help groups in the world are not helping her get through this. What would help her get through it is to know those people, those two murderers will never get out again. What do I tell her?
The Honourable Member for Hochelaga. What we can say to this lady is that we understand what happened. And the first thing we have to cover here is public safety. That's what the NDP believes in. That is why the NDP decided to support this bill and bring it forth past second reading. But public safety, particularly the safety of that person's child, is something very dear to our hearts.
Resuming debate, the Honourable Member for Edmonton Centre.
Well, thank you very much, Mr. Speaker. And I'm pleased to participate in the second reading debate in support of Bill C54, the Not Criminally Responsible Reform Act. I'm going to focus my comments around how this bill reflects and builds upon the legal foundation provided by the Supreme Court of Canada on controlling the risks posed by the accused who are found not criminally responsible on account of mental disorder, or NCR. This bill will provide enhanced guidance to the courts in applying several key legal tests that are present in the mental disorder regime of the Criminal Code. This is the part of the Criminal Code which deals with the mentally disordered accused, including those who are found NCR. The introduction of more straightforward terminology and clearer language proposed in Bill C54 will better ensure that the courts accord proper weight to the protection of the public. Mr. Speaker, it's about keeping it as simple and clear as possible. At the heart of this bill is a concern for protecting public safety, which is the first and foremost duty of any government, and everybody in this House agrees with that. Certainly my constituents have told me that time after time after time. It has been recognized by the Supreme Court of Canada on numerous occasions, most recently in the 2010 case of R.V. Conway, as a paramount duty of review boards in the context of dealing with NCR accused. In that case, the Supreme Court noted that while an NCR patient's liberty must be a major occupation of these boards, it is still situated within the fence posts of public safety. That is the first priority, and if it doesn't fit within those fence posts, it's not going to happen. What Bill C54 proposes to do is to clearly articulate those fence posts in an accessible and forthright manner. The bill would ensure that the procedures put in place for reviewing the disposition of NCR accused are tailored responses that take into account the risk that any particular individual poses to society at large. It's not a cookie-cutter approach, Mr. Speaker. It's a case-by-case basis. This is why Bill C54 proposes to introduce the new designation of a high-risk NCR accused. It is not intended to apply to all persons found NCR. Rather, it is only directed at a subset of these persons after a court is first satisfied that there is a substantial likelihood that the accused will use violence that could endanger the life or safety of another person, or that a court is of the opinion that the acts that constitute the offence were of such brutal nature as to indicate a risk of grave physical or psychological harm to another person. With reference to some earlier debate we had with the member from Toronto Centre and others in the Liberal Party, I would have to ask again the rhetorical question: what level of risk is acceptable to the public? And I would say very little. By introducing this designation, the bill responds to the paramount interest in protecting public safety cited by the Supreme Court in Conway, and specifically, this bill addresses the cases at the highest end of the risk spectrum and applied in the appropriate circumstances. Mr. Speaker, Bill C54 also builds on the Supreme Court of Canada's 1996 decision in Winco v. British Columbia. In that case, the court interpreted the phrase in the existing section 672.54 of the Criminal Code regarding what is, quote, a significant threat to the safety of the public, unquote. This is the test used in the NCR regime by a court or review board in determining whether an accused should be discharged absolutely or with conditions or detained in a hospital. In Winco, the court concluded that a, quote, significant threat to the safety of the public, unquote, means a real risk of physical or psychological harm to members of the public that is criminal in nature and serious in the sense of going beyond the merely trivial or annoying. Again, I would ask, Mr. Speaker, what level of risk is acceptable to the public? And the answer that my constituents would give, and I think most people would give, is very little. Bill C-54 is consistent with the Supreme Court of Canada's approach. It clarifies the meaning of significant threat to the safety of the public by specifically defining in the law as, quote, a serious physical or psychological harm to members of the public, including any victim or witness to the offence, or any person under the age of 18 years, resulting from conduct that is criminal in nature but not necessarily violent, unquote. This clarification is specifically intended to adopt and confirm the interpretation of the Supreme Court of Canada in Winco. It ensures that a court considering the threat posed by an NCR accused is able to take into account all of the appropriate circumstances, including criminal conduct that is not overtly violent, but may nonetheless signal a real risk to the public. Mr. Speaker, this definition also addresses a key concern that we have heard time and time again, namely the need to ensure that victims' interests are acknowledged in the criminal justice system. With this amendment, Bill C-54 makes it clear that when a court or review board considers what is a threat, it must consider not only the general public at large, but also any victims, witnesses, or any person under the age of 18. This will help ensure that any particular threat or danger to the victims is not forgotten or overlooked. Safety of the public must include the safety of its most vulnerable members, and Bill C-54 recognizes and affirms this objective. I welcome the proposed addition of this specific definition to the mental disorder regime. It will help to clarify this crucial point of law and will provide assistance to the courts and review boards who have to make these very challenging decisions. Mr. Speaker, Bill C-54 aims to clarify another important issue, which is the meaning of the phrase in Section 672.54 of the Criminal Code, quote, disposition that is least onerous and least restrictive to the accused person. No mention of victims. That phrase refers to the duty of the review board to choose between the possible dispositions for an NCR accused, including absolute or conditional discharge, as well as detention in a hospital, subject to any appropriate conditions. However, it is also a phrase that is not easily understood or as clear as it could be. Bill C-54 therefore proposes to replace this phrase with far more accessible and understandable wording of, quote, disposition that is necessary and appropriate in the circumstances, unquote. In other words, Mr. Speaker, some balance between the rights of the victims and the rights of the NCR accused. This change is consistent with the authorities that I have referred to that held that in deciding between dispositions, safety of the public must be the primary consideration. What is a necessary and appropriate disposition will depend on the threat posed by the particular NCR accused. Bill C-54's language would still require review boards to consider all of the relevant circumstances in making such a determination. Mr. Speaker, I think many will appreciate that reviewing legal areas such as the appropriate disposition for NCR accused are not always easy for Parliament or the courts to discuss. Decisions of the courts, such as Winco and Conway, cases that I referred to, can signal to Parliament that an area of law would benefit from clarification from the legislature. Bill C-54 is an important and significant step in this direction as it pertains to the legal regime for determining appropriate dispositions of NCR accused. It is a bill that will clearly indicate that the protection of the public is the guiding principle that courts and review boards must address in arriving at dispositions under the regime. And this balanced bill deserves the approval of this House because it also should be a guiding principle of this place, that we find the correct balance between the rights of victims when we're dealing with criminal justice and the rights of the accused. In this case, as always, Mr. Speaker, the rights of victims, the protection of the public, should be our first priority. I urge members to vote for this bill. From what we're hearing, I'm certain it will pass second reading and move to committee where it can receive fuller discussion, receive input from witnesses, address some of the points, legitimate points that have been brought up tonight by members in the House on both sides of the House. So, Mr. Speaker, I do encourage all members of this House to join me in supporting Bill C54. Let's get it to committee. Let's do the right thing for victims while still doing the right thing for those who are caught up in the justice system through no fault of their own, through mental illness. Thank you, Mr. Speaker.
Questions and comments? The honourable member for Halifax.
Thank you, Mr. Speaker. I thank my colleague across the floor for his speech. I have a question that I'm looking for an answer to. The member for Selkirk Interlake mischaracterized my position a little bit, where he said that I said this bill was unwarranted. I never said anything of that nature. I'm looking forward to actually seeing what evidence there is out there to say that we need this bill. So I'm looking forward to hearing that at committee. But my question then is, so this bill specifically, it would make explicit the fact that the review board needs to take into consideration public safety. This is the paramount consideration. So that's what it makes explicit. What I want to know is, aren't the boards already making public safety the paramount consideration? One would think, I've read the criminal code and I think it says so explicitly, but even if it didn't, one would assume that's the paramount consideration. So how is this bill actually doing anything different? That's my question to the member.
For Edmonton Centre.
Well, thank you very much, Mr. Speaker, and I thank my colleague across the way for the question. And it's not a bolt of lightning or anything like that that says, throw out the old and bring in the new. It's a matter of, as I said, it's a matter of refining what's there. It's a matter of making the wording more clear so that review boards, can have a little more guidance, a little more clarity. And just one of the things that I mentioned, 672.54 of the criminal code, that says the disposition that is least onerous and least restricted to the accused person. It says nothing about victims. What we're talking about, replacing that with, is disposition that is necessary and appropriate in the circumstances, which is a broader statement, but it also brings into play the rights of the victim as well as the rights of the accused. So it's a more balanced approach in our view. My colleague raises legitimate questions. These aren't simple issues. So this is an effort, Bill C54, to make it more clear, to make it easier for boards to come to the appropriate decision. And I think once we get to committee, there will be another opportunity to address more of these issues in a more fulsome manner.
Questions and comments? The honourable member for Newton North Delta.
Thank you, Mr. Speaker. As has been said, we're pleased to support this bill at this stage, but we have lots of questions, and that's why it goes to committee stage, so we can get those clarified, we can have debate, and we can have amendments. That is, if the Conservatives accept any constructive amendments, but on this side, we always live in hope. Anyway, so my question to the Speaker across the way is basically, what is the difference between this bill and the current legislation, and do the courts and the review boards not already take public safety into consideration when they make their decisions?
The honourable member for Edmonton Centre.
Well, I would just say to my honourable colleague, like for all of us, hope springs eternal. But, my colleague from Halifax is wearing orange and my colleague from Newton North Delta is wearing orange, but they asked the exact same question as well. So well, I'm sorry, I'll have to give you the same one. Mr. Speaker, I'll have to give them the same one that I gave just a moment ago, and that is to clarify some of the language to make it simpler and more clear to the review boards that this is a balanced approach between the rights of the victims and the rights of the NCR accused, and that it's not a cookie-cutter approach, that they do have to take public safety as the primary consideration, but in a balanced and more definitive way. And these are the kind of questions, Mr. Speaker, that can be addressed at committee with various expert witnesses, and to find a wording that might make it even more clear than what's in the bill right now.
Reprise de débat.
Resuming debate. The honourable member.
NCR people.
Speaker, I mention this because by looking at real tragedies such as the Tim McLean murder or the Turcotte murders, the public is understandably outraged at what they perceive as a miscarriage of justice. The majority of Canadians usually don't agree with the verdicts given, and they don't agree with the way the cases are treated in general. We here in the NDP support C54 at second reading because we think that we need to look seriously at how review boards handle reviews, as well as how victims' rights are considered during these reviews. But I want to pause and reflect here because this bill needs to be studied in committee. We must not let the outrage outweigh sound policy decisions in deliberating C54. It's hard as a parliamentarian to separate emotion or personal ideas of justice from what is actually a sound and informed policy deliberation. I'm encouraged to hear sound policy deliberations from my colleagues on both sides of the aisle tonight, and I hope that we can come to consensus to work together to put public safety first when complying with the rule of law and the Canadian Charter of Rights and Freedoms. Comme un être humain, comme père,
as a human being and as a father, I am disgusted, perplexed, and cannot understand how a man can kill his own children. This is horrible. I have deep feelings about this. Who could not feel strongly in reading headlines about such crimes? I was terribly saddened when I heard about the Guy Turcotte case as well. Such cases, which are highly publicized, make us doubt the efficiency of the current approach. And I'm thinking of Isabelle Gaston, all the victims. I would like to know how we can help victims in this process. You must understand that Isabelle Gaston, the only thing she really wanted was to see her two children alive. Anne-Sophie and Olivier. But no court decision, no decision can bring her children back to life. After the trial, Ms. Gaston wanted the media to leave her alone so she could move on with her life. Mr. Speaker, how can we help victims in this process? That is the question we must ask ourselves. The member from Hochelaga talked about the failure of action for victims. I find that the government financial compensation will never console or comfort a parent who has lost children or a child. As individuals, we cannot identify victims' needs, nor determine them. Over the next few weeks, I hope we will speak with mental illness experts, with victims, as well as with provinces, in order to find out what approach they think is the best.
Policy, we will not be better off, Speaker. If we make only cosmetic changes for the sake of the government to merely appear as if it's acting on this file, we won't be any further advanced on this. The government has had 6 months to put this on the agenda. It's waited 6 months to put this on the agenda. Okay, so Speaker, let's be honest here. We need expert opinions. We need to consult with victims, with provinces, because if the government was honest, it would admit that both crime and mental illness are wicked problems. And if we plan to solve them, we will require complex, well-thought-out solutions. And even then, Speaker, we might not arrive at the right solutions. The definition of a wicked problem is a problem that has a difficult or even impossible to solve because of complex interdependencies, contradictory and incomplete requirements. When approaching a wicked problem, Professor Nancy C. Roberts has said there are three main approaches. The first is an authoritative approach, which takes all the competing points are eliminated, it's simplified, power is vested into fewer hands, and the consequence is that not all points may be taken into account to solve the problem. The second is a competitive, it's an adversarial approach where you have two sides coming at each other, and in that approach, knowledge sharing might not happen, and parties who care about their solution winning might not come to consensus to find the best approach. The third approach is the collaborative approach. And it's to engage all stakeholders and to come to a consensus, to come to a common agreed approach. Over here in the NDP, we believe in that third approach, that collaborative approach. And in the coming weeks, we should meet with mental health experts, victims, and provinces to find out what they believe is the best approach. However, and I should caution members here, we do not want to play political games or use tragedies for political advantage with this file. Let's take Samuel Clemens' words into account, Speaker, and focus together, working together on crafting what is the best policy. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Burnaby, New Westminster.
Thank you very much. I appreciated the comments of the member from Vaudreuil-Soulanges. She's a very eloquent new member of the House and does a very effective job here in the House of Commons. I appreciated his remarks, particularly when it comes to the difference between what legislation purports to do and what it actually does. And the reality is, Mr. Speaker, when we look at the legislation, what goes beyond that is what resources are being allocated by this federal government. In other words, what are they actually doing to provide the resources to support the victims and support this legislation? And Mr. Speaker, throughout the evening, we've been asking questions. The member from Vaudreuil-Soulanges has been asking questions. We haven't gotten answers back from the government about how they are going to resource this legislation. It seems apparent that it is going to be put on the backs of the provinces, Mr. Speaker. And when we look at the cutbacks that this government is putting in the in health transfers, cutting back basically over the next few years 50% the health care transfers, we have concerns about whether or not these this legislation is actually being adequately funded. So I wanted to ask the member from Vaudreuil-Soulanges, does he share the concerns about the government not providing the funding to support the legislation?
The Honourable Deputy de Vaudreuil-Soulanges.
Honourable Member from Vaudreuil-Soulanges. Mr. Speaker, I can tell you that I'm very concerned that in terms of funding, the government has not done its homework in planning an adequate transfer to the provinces so that they can meet their own needs. And in dealing with mental illness, if we look at the facts, and I'm reading in the document here, it says, let's suppose that the new formula is maintained indefinitely. The member can see that the federal share of expenses in terms of health expenditures for provinces and territories will be reduced by 24% between now and 10.6% between 2011 to 2035 and 2036. And to 13.8% between the following 25 years, and then 11.9% for the rest of the period that is covered in these projections. So that means that over the long term, we see diminishing transfers in terms of health care expenditures for provinces and territories. So I'm very concerned, Mr. Speaker, that the government has not sufficiently planned in order to meet provincial needs on these issues.
Mr. Speaker, and I thank my honourable colleague from Vaudreuil-Soulanges. That was a very fine speech indeed. I want to turn our attention to another piece of this, which is, as much as we can say we want to address a problem, and the problem is the people who are held not criminally responsible, if the legislation that's passed is not compliant with the Charter, it will make things worse even with the aims that the Conservatives claim they want to address here. So I asked my honourable colleague if he's familiar with the position of the Canadian Bar Association. They've looked at this, and they remove the insertion, and rather the removal of the language least onerous and least restrictive requirement, which is essential in their mind to constitutional validity of the provisions that we now have, and that the Supreme Court of Canada has underscored this, that if we remove, as C54 does, the language least onerous and least restrictive requirement, we may well find that this legislation is susceptible to a constitutional challenge, that it will fail to survive.
L'honorable député de Vaudreuil-Soulanges.
Honourable member from Vaudreuil-Soulanges.
With the government side in committee and to talk about the balance between the rights of individuals and the rights of victims. These are things that can be explored and debated in committee, and we can discuss serious questions about the Charter and that balance between the rights of victims and rights of individuals. That's why we're supporting at second reading, so that it can get to committee and we can discuss about these issues.
Resuming debate, the honourable member for Barrie.
Thank you, Mr. Speaker. I'm thankful to have the opportunity today to contribute to the second reading debate on Bill C54, the Not Criminally Responsible Reform Act. This bill proposes to amend the mental disorder regime in the Criminal Code and the National Defence Act to strengthen their ability to better protect the safety of the public, as well as do a better job at responding to the needs of victims in the mental disorder regime. It may be useful to provide a bit of background on the existing mental disorder regime before I outline the amendments proposed in Bill C54 and why there are important reforms. A fundamental principle of our criminal law, including the mental disorder regime, is that a person must be morally blameworthy to be criminally liable for a wrongful act or omission. They must have the mental capacity to know and appreciate what they are doing, and the mental capacity to distinguish between what is right and wrong. Also, they must be able to communicate and give instructions to their lawyer and understand the nature and consequences of a criminal trial in order to be tried. If, at that time that the act is committed, a person suffered from a mental disorder that rendered them incapable of knowing what they did or that it was wrong, the trial court can find the person committed the act in question, but order a verdict of not criminally responsible on account of mental disorder. If at that time of trial, the mentally disordered person does not have the capacity to understand the nature and the consequences of a criminal trial, they may be found unfit to stand trial. After either of these findings, the person will be dealt with according to the mental disorder regime, which is designed to balance the twin goals of public protection and fair treatment of the accused, usually by provincially appointed review boards. The review boards are comprised of at least 5 members with legal and psychiatric expertise. As I noted, this bill contains elements which addresses both public safety and victims. In terms of the public safety reforms, the bill would amend the Criminal Code to clarify that public safety is paramount in consideration for the review board decision-making process. Although the Supreme Court of Canada has said that the public safety is already paramount consideration, most recently in the 2000 judgment Regina and Conway, this proposed amendment will ensure consistent application in cases across the country. The reforms would also codify the Supreme Court of Canada's interpretation of significant threat to the safety of the public, which is the current test for determining whether review boards can continue to supervise the not criminally responsible accused. The Supreme Court interpreted this phrase in the 1999 case in Winco. The amendment would also clarify the accused need not pose a threat of violence, but must pose a real risk of physical or psychological harm to members of the public that is more than merely trivial or annoying, and it must be criminal in nature. This will ensure this test is applied consistently across all jurisdictions. Bill C54 also proposed to create a new high-risk mentally disordered accused designation scheme. This new scheme would only apply to the accused who were found not criminally responsible for a serious personal injury offense. The mental disorder regime defines a serious personal injury offense as an indictable offense involving the use or attempted use of violence, conduct endangering the life or safety, or sexual offenses. In these cases, the Crown would apply for the high-risk designation to be made by the court. This designation can be made in 2 situations. The first is where the court is satisfied that there is a substantial likelihood that the not criminally responsible accused will commit violence that endangers the life or safety of another person. The second part is that the court is of the opinion that the offence for which the not criminally responsible accused was found to be not criminally responsible was particularly brutal, so as to indicate a risk or grave harm to the public. Accused persons who are found to be unfit are not included in this high-risk designation scheme because they have not yet been tried and determined by a court to have committed the act. The effect of such a judicial designation is to protect the society from a high-risk individual and prevent the accused from being conditionally or absolutely discharged. As well, a high-risk, not criminally responsible accused will not be permitted unescorted passes in the community, and this is particularly important. Escorted passes would only be permitted for medical reasons, and only when a structured plan is in place to ensure the safety of the public. I think it's important, Mr. Speaker, to clarify that the high-risk designation is not permanent. Once the review board is satisfied that the high-risk, not criminally responsible accused no longer poses a substantial likelihood of committing violence that would endanger the life or safety of another person, they must make a recommendation to the Superior Court of Criminal Jurisdiction for review. The court will then hold another hearing to determine whether or not the designation should be removed. And if they reach the same conclusion as the review board, the designation must be revoked. The accused would then become a regular, not criminally responsible accused and would be dealt with under the regular procedures of the mental disorder regime. I think these are balanced proposals that seek to protect both the safety of the public as well as the rights of the accused persons to fair and appropriate treatment. Now I would like to turn to the victim-related reforms. The mental disorder regime already offers many opportunities for victims to be involved in this process. They can attend hearings and present a victim impact statement. The proposed reforms will enhance victim involvement by providing that victims be notified on request when a discharge order has been made. This will ensure that victims have an advance notice about the fact that they may run into the mentally disordered accused. This is especially concerning if they are released in a small community. The law would also be clarified explicitly to provide that the safety of victims be considered in the decision-making process. Further, Bill C54 proposes to clarify that the review board shall consider whether or not it is desirable to issue a non-communication order between the not criminally responsible accused and the victim. The review board will also consider whether or not to order the not criminally responsible accused not to attend at a specific place, for example, the victim's home or place of work. In closing, Mr. Speaker, I would like to encourage all members to support this bill's passage at second reading. This is a bill which provides for balanced measures to protect public safety and enhances victim involvement in the mental disorder regime, reforms which I think we should all support. Thank you for listening.
Questions and comments? The Honourable Minister of State for Western Diversification.
Thank you, Mr. Speaker. I thought that I would like to have the member again emphasize how important it is for the victims to be part of the decision making and how important this legislation is for the public safety to be at the forefront of decision making. If you'd like to elaborate.
The Honourable Member for Barrie.
Mr. Speaker, and thank you very much for the question. I think that is certainly one of the important aspects of this bill, that it takes into consideration the role of the victims and the fact that it would be, first, to go through an ordeal where you're the victim is a huge challenge in the first place, but then to have this memory revisited by potentially having the person who's been convicted in your small town or in your place of work and not know about it would be harrowing. And that's why this bill certainly takes into consideration the rights of the victims and involves them in the process to have that advance notice, to have the ability to have conditions placed upon that release. I think is very it's the right balance. It's the right balance in this bill as it recognizes the role of the victims, and I applaud the minister and their team for putting that in this bill C54.
Questions and comments? L'Honorable Député Montmorency Charlevoix Haute-Gaudnon.
The Honourable Member from Montmorency Charlevoix. Thank you, Mr. Speaker. I'm sure the Honourable Member will agree with me that such a bill, by amending all kinds of measures, and enforcing a certain follow-up with these people and all the rest of it will involve costs. Following the assessment of such costs, we can see two possibilities before us. Either we pass the bill on to others, or our own government will have to pay those costs itself. Were those costs not to be covered under any particular program, has the government decided whether they are going to pass the bill on to the provinces, or does the government plan to cover the costs itself?
Thank you, Mr. Speaker. And on the issue of cost, I would note that this government has invested a lot into mental health. Since 2006, the government has invested nearly $90 million into mental health for prisoners. In terms of transfer payments and costs that the provinces accrue, the provinces have received transfer payments that now total $62 billion this year, nearly a 50% increase since 2006. So I think this government has been very generous with the provinces. But what it comes down to is making sure that we have balance and fairness in our justice system. And if there is a cost associated with protecting and being aware of the rights of victims in the process and ensuring public safety in our communities, then that is certainly the right decision to be made.
Questions and comments? The Honourable Member from Hochelaga. Thank you, Mr. Speaker. After my speech a little earlier, I had a question about the mother of a person who was assassinated, and what we could say to such a mother. In my family, we experienced a similar situation. My cousin was tortured and then killed. The person who killed him spent the rest of his life in jail and died in jail and never got out of jail. So this bill would not have done anything to help that person's family. So how can you express so much confidence in this bill, which really, in the end, doesn't change much at all? What is there that is so useful and profound in this bill?
Thank you, Mr. Speaker. In terms of the specific case that was raised by the member, obviously I don't know the details of that case, but this legislation is important because it does three things. It enhances victims' rights, it puts public safety first, and it creates a very important high-risk designation. And I want to speak directly to the high-risk designation. The legislation would create a new designation to protect the public from a high-risk, not criminally responsible accused. Upon this designation by a court as a high-risk, a not criminally responsible accused must be held in custody and cannot be considered for release by a review board until their designation is revoked by a court. And I think we all know that this is important in our communities. And if you're saying what's the point of this bill, it's about protecting the public safety. And obviously, there's a lot of support for this in the country. I think any of us that have constituents that have heard about these reforms, there is a lot of support for it. And I'm glad that this government is putting victims first and is protecting public safety across the country.
Resuming debate, the Honourable Member for Langley.
Thank you, Mr. Speaker. It's a real honor to be able to speak to the second reading of C54 and the Not Criminally Responsible Reform Act. As we know, the Government of Canada is committed to protecting victims of crime and to making our streets and our communities safer for all Canadians. To this end, last February 8th of this year, our government introduced the Not Criminally Responsible Reform Act. The Act would ensure that public safety comes first in the decision-making process with respect to accused persons found not criminally responsible on account of a mental disorder, and to enhance the safety of victims and promote greater victim involvement in the Criminal Code mental disorder regime. Mr. Speaker, when this bill was first introduced last February, I'm sure that many of us, if not all of our offices, received support from across this great country. We each receive a lot of input through emails, phone calls, letters, and when we're at community meetings, and time again, when this was first introduced in February, there was a lot of positive response to this. Canadians want this. Victims need this. Mr. Speaker, the Criminal Code mental disorder regime applies to a very small percentage of accused persons. Under Canadian criminal law, if an accused person cannot understand what the nature of the trial is or its consequences, and cannot communicate with their lawyer on account of a mental disorder, the court will find that the person is unfit to stand trial. Once an accused becomes fit to stand trial, they will then be tried for the offense for which they were initially charged. If a person is found to have committed the act that constitutes an offense, but lacked the capacity to appreciate what they did, or know that it was wrong due to a mental disorder at the time, the court makes a special verdict of not criminally responsible on account of a mental disorder, also known as NCR. They are neither convicted or acquitted. A person found either unfit to stand trial or NCR, Mr. Speaker, the board then decides on a course of action. Under the current law, the review board can make one of three possible decisions. If the person does not pose a significant threat to public safety, an absolute discharge could be made, or a conditional discharge or detention in custody in a hospital. Now, this bill, C54, proposes to amend the mental disorder regime, which deals with accused persons who are found to be unfit to stand trial or have an NCR. The legislative amendments to the mental disorder regime of the Criminal Code proposed in the Not Criminally Responsible Reform Act would explicitly make public safety the paramount consideration in the court and the review board decision-making process related to accused persons found to be NCR or unfit to stand trial. The legislation would amend the Criminal Code to create a process for the designation of NCR accused persons as high risk where the accused person has been found NCR of a serious personal injury offense, and there is a substantial likelihood for further violence that would endanger the public, or in cases in which the acts were of such a brutal nature as to indicate a risk of grave harm to the public. Now, there's been a lot of comment that has been made in this House over the last number of hours, and hopefully that clarifies this. This is to be considered in the most dangerous and extreme cases. Those designated as high-risk NCR accused persons would not be granted a condition or absolute discharge, and the designation could only be revoked by the court following a recommendation of the review board. This designation would apply only to those found NCR and not to persons found unfit to stand the trial. The proposed legislation outlines that high-risk NCR accused persons would not be allowed to go into the community unescorted. The public supports that. And escorted passes would only be allowed in narrow circumstances and subject to significant conditions to protect the public safety. Canadians support that. Also, the review board may decide to extend the review period for up to 3 years for those designated high risk instead of annually. Canadians support that. The high-risk NCR designation would not affect access to treatment by the accused. Canadians support that. In addition, the proposed reforms would codify the meaning of significant threat for safety, significant threat to the safety of the public, which is the current test used to determine whether a review board can maintain jurisdiction and continue to supervise a mentally disordered accused. It would clarify that the risk to the public safety must be criminal in nature, but not necessarily violent in form, for restrictions to be imposed on the accused. The legislation would enhance the safety of victims and provide them with opportunities for greater involvement in the criminal code mental disorder regime by ensuring that they're notified upon request when the accused is discharged.
allowing non-communication orders between the accused and the victim, and ensuring that the safety of victims be considered when decisions are being made about an accused person. Mr. Speaker, this is what I have heard also from Canadians, the importance of the consideration of the families of the victims. Often we've heard that the consideration of these families that are dealing with a loss and a traumatic situation in their lives, their consideration and their involvement need to be considered, and in way too often, Mr. Speaker, that has not happened. Provisions of the proposed legislation would also help to ensure consistent interpretation and application of the law across our great country. These proposed reforms would not change the existing criminal code eligibility criteria for the exemption from criminal responsibility on account of mental disorder. Since the introduction of the Federal Victim Strategy in 2008, our government has responded to the needs of victims of crime in an effort to give them a more effective voice in the criminal justice system. And Canadians are very happy with that, what has been accomplished. Funding has been provided to projects and activities that enhance victim assistance programs across Canada, that promote access to justice and participation in the justice system and the development of law, policies, and programs. To promote the implementation of principles, guidelines, and laws designed to address the needs of victims of crime and articulate their role in the criminal justice system. Contribute to increased knowledge and awareness of the impact of victimization, the needs of victims of crime, available services, assistance in programs and legislation, and also to promote, encourage, and enhance governmental and non-governmental organizations' involvement in the identification of victims' needs and gaps in service, and in the development and delivery of programs, services, and assistance to victims, including capacity building in the non-governmental organizations. Mr. Speaker, the legislation in review, and how much time do I have, Mr. Speaker? 1 minute. So the legislation will enhance victims' rights. The legislation will enhance the safety of victims by ensuring that they are specifically considered when decisions are being made about accused persons, found NCR. We will put the public safety first. The legislation will explicitly set out that public safety is the paramount consideration in the decision-making process, and the legislation would create a new designation to protect the public from high-risk NCR accused. Mr. Speaker, Canadians want this, Canadians need this, and I encourage all members to support this. Thank you.
Question and commentaire, l'honorable député.
Questions and comments? Honourable member from Hochelaga. Thank you, Chair.
I'll repeat the last question I asked. I was talking about my cousin who'd been tortured and killed. The murderer was in prison and never got out because the crime was so horrible. He died there. The answer I got was, we want to protect the public. How could this bill have better protected the public? Because that criminal in particular stayed in prison. It didn't apply to him. So what more will this bring?
For Langley.
Thank you, Mr. Speaker, and I thank the member for the question. Mr. Speaker, are very sorry for the loss that she has experienced. But you cannot base law on any one example. We've heard examples where we have in the Winnipeg area, Manitoba, that a person has been released, and it's created a lot of angst within the community that is their safety at risk. And so, but you have to have legislation built on logic that reaches a balance. What we are right now, Mr. Speaker, is at second reading. And at second reading, if this passes, it will go to committee, and the Justice Committee will deal with this legislation and possibly make some changes to make it better. But you cannot build legislation on one example, but I thank her for her question.
Questions and comments, the honourable member for Etobicoke Lakeshore.
Thank you, Mr. Speaker, and I thank my colleague for his speech. One of the things he described in his speech is the discretion that's utilized when it comes to applying the not criminal responsible provisions in the bill. Could maybe the members expand on why this is really not a case of one size fits all, that this is a tool that's being deployed at the disposal of prosecutors? Well, they'll look at the specific examples of the case. Could you expand on why this is a useful adaptation for the judicial system, looking at specific cases, and it's really not a case of treating all cases the same?
The honourable member for Langley.
Thank you, Mr. Speaker. Very good question that my honourable member brings up. The courts still have discretion, and if the courts deem an individual not criminally responsible, but being involved with a very serious offence and possibly a risk to the community, that individual will have this high-risk designation. That could be removed at a future time if the review board applies to have it be removed. But right now, these people, somebody that's found not criminally responsible, does not have that designation. So having that designation for the very serious offenses provides the courts to have discretion, but it also provides another step of assurance that public safety is paramount.
Questions and comments? The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I want to return to the concern that I've been expressing this evening that despite good intentions, perhaps, in the way this legislation is drafted to deal with a concern the public has, and I do feel that it's driven by the headlines as opposed to empirical evidence, that we may inadvertently make the situation worse. The courts have been very clear that the not criminally insane provisions and much of the law that surrounds them must be seen in the context of mental health and treatment and not of a more punitive approach. I just, in evidence of this, if I have permission, just cite briefly from Mr. Justice Binney in the Owen case, quote, "It is of central importance to the constitutional validity of this statutory arrangement that the individual be confined only for reasons of public protection, not punishment." And I put it to my friend from Langley that this bill in many areas seems to trespass from the preventative mental health focus to one that is treating mentally ill persons as criminals and subject to more severe punishment.
The honourable member for Langley.
Mr. Speaker, I thank the member for her question, and I want to thank her for being here at these late hours. We have, as parties, opportunity to take a breather, but she is here faithfully representing her community, and I want to thank her for that. It takes a lot of effort to do it by yourself. Mr. Speaker, but her question, whether or not this is punitive, absolutely not. Mr. Speaker, this has reached a balance where the courts still have discretion to put a classification on somebody that presents or could present a very high risk of reoffending. The paramount consideration is does this designation need to be put on this individual to protect the public? And the courts have the discretion. If that designation is put on, it would be the courts that could, only the courts that could remove it. Thank you.
Resuming debate, the honourable member for Vancouver Kingston.
Thank you, Mr. Speaker. I am pleased to rise to speak to this very profoundly important bill that is before this House, Bill C54, one that I think calls for all parliamentarians to reach deeply into their experience, deeply into their commitment to making good, sound public policy in this country, and that calls upon us to, I think, balance some of the most important values that we have as not only as parliamentarians but as Canadians. This legislation would amend the criminal code to create a process for the designation of not criminally responsible accused persons as high risk where the accused person has been found not criminally responsible of a serious personal injury offence, and there is a substantial likelihood for further violence that would endanger the public, or alternately in cases in which the acts were of such a brutal nature as to indicate a risk of grave harm to the public. Mr. Speaker, those designated as high-risk accused persons would not be granted a conditional or absolute discharge, and the designation could only be revoked by the court following a recommendation of the review board. It's important to note that this designation would apply only to those found not criminally responsible and not to persons found unfit to stand trial. The proposed legislation outlines that a high-risk accused person would not be allowed to go into the community unescorted, and escorted passes would only be allowed in narrow circumstances and subject to sufficient conditions to protect public safety. Also, the review board may decide to extend the review period for up to 3 years for those designated high risk instead of annually. The high risk NCR designation would not affect access to treatment by the accused. Mr. Speaker, this bill would also speak to the very important role of victims in this important matter. These changes would ensure that victims are notified upon request when an accused that has been found guilty of a non-criminally responsible or receive a non-criminally responsible designation is discharged. It would allow non-communication orders to be issued between the accused and the victim, and finally would ensure that the safety of victims be considered when decisions are being made about an accused person. Provisions in the proposed legislation would also help ensure consistent interpretation and application of the law across the country. These proposed reforms would not change the existing criminal code eligibility criteria for the exemption from criminal responsibility on account of mental disorders. Mr. Speaker, this is a very difficult issue for victims, families, and communities. I would say it's a very difficult issue for all of those involved in the criminal justice system, from the police to the prosecutors to the defense bar to the judiciary. The public safety must come first when complying with the rule of law and the Canadian Charter of Rights and Freedoms, but it calls on very important balancing to be done. A number of recent cases that received significant media attention in Canada raised questions about the appropriateness and effectiveness of the current approach. In particular, we want to know how we can help victims better in the process and deal sensitively, fairly, and effectively with not criminally responsible offenders. In the coming weeks, we New Democrats want to talk with mental health experts, victims, members of the bar and provinces to find out what they believe is the best approach. It is important to note that we New Democrats do not want to play political games with this file. We must focus on the policy's merits and the serious issues that are involved.
You know, one of the questions that we've had is what happens to someone who is found not criminally responsible? Well, if a person is found to have committed an act that constitutes an offense, but lack the capacity to appreciate what they did, or know that it was wrong to do due to a mental disorder at the time, the court makes a special verdict of not criminally responsible on account of mental disorder. The person is neither convicted nor acquitted. Instead, the person is referred to a provincial or territorial review board who decides on the course of action that both protect the public and provides opportunities for treatment for the underlying mental disorder. Under the current law, a review board can make one of three possible decisions. If a person does not pose a significant threat to public safety, an absolute discharge, a conditional discharge, or detention in custody in hospital. One of the other questions that would be asked is how will the proposed amendments better protect Canadians? The highest priority of this government is to keep citizens safe. This legislation amends to the mental disorder regime of the Criminal Code proposed in the Not Criminally Responsible Reform Act would explicitly set out that public safety is the paramount consideration in the court and the review board decision-making process relating to the accused persons found to be not criminally responsible on account of mental disorders or unfit for stand trial. The legislation would also amend the Criminal Code to create a process to designate an accused person found NCR for serious personal injury offenses who poses a substantial risk on committing further violent acts as a high-risk accused. Upon being designated by the court, a high-risk NCR accused must be held in custody and cannot be considered for release by a review board until their high-risk status is revoked by the court. The other consequences of being designated as a high-risk NCR accused include that their review period could be extended up to 3 years. Such individuals would be not entitled to unescorted passes, and they could only obtain an escorted pass in narrow circumstances and subject to sufficient conditions to protect the public safety. Why does the high-risk NCR accused designation apply to those found unfit to stand trial? Mr. Speaker, the high-risk accused designation only applies to following verdict of an NCR because the person was found by the courts to have committed the alleged acts, and an unfit accused has not yet been tried for the offense. If a person is not fit to stand trial, they would not be fit to participate in a high-risk hearing. The majority of the unfit accused become fit within a very short period of time, at which point they will be tried. They may be convicted as a charged, acquitted, or found NCR. If they are found NCR, they could be subject to a high-risk designation if the criteria is met. Will legislation increase the possibility of an NCR accused person being kept in custody longer or indefinitely, regardless of whether they continue to pose a risk to society? This is a good question. But as long as the NCR accused person continues to pose a risk to public safety, the individual will remain under supervision of the provincial or territorial review board. The issue of whether they are kept in custody in a hospital or under conditional discharge depends on the level of risk in each case. The creation of a high-risk NCR accused designation further enhances public safety while ensuring judicial and review board oversight and ongoing detention of these individuals. The possibility of the indefinite detention exists under current law and will continue to exist under the proposed law. Why is this legislation tightening the eligibility criteria for the Criminal Code Defense of Mental Disorders? The purpose of the legislation is focusing on the decision-making process after a person has been found NCR. This proposed legislation responds to the primary concerns of the stakeholder, including victims as well as provincial and territorial governments. Will these amendments apply to all accused persons who suffer from a mental illness who come into contact with the criminal justice system? No. This bill only applies to accused persons who are either found unfit to stand trial on account of mental disorder or if they're found by the court to be NCR. What is the difference between someone who is found unfit to stand trial and someone who is found not criminally responsible on account of mental disorder? That is, again, another good question. Under criminal law, if an accused person cannot understand the nature of the trial or its consequences and cannot communicate with their lawyer on account of mental disorder, the court will find that person is unfit to stand trial. Once an accused becomes fit to stand trial, they will then be tried for the offense with which they were initially charged. If a person is found to have committed the act that constitutes an offense, but lack the capacity to appreciate what they did or know that is wrong due to mental disorder at the time, the court makes a special verdict of not guilty, criminally responsible on account of mental disorder. Such a person is neither convicted or acquitted. Do these reforms address situations like the one that occurred with Ashley Smith? No, they do not. This bill does not deal with the correctional system. Persons found with NCR are unfit to stand trial on account of mental disorder are not in prisons. They may, however, be detained in a hospital for psychiatric facility. What information or research does the government have on reoffending by NCR accused persons to justify these reforms? There is a limited amount of data on the rates of reoffending by NCR accused persons. What we do know about NCR accused persons is that the majority have committed serious acts that brought them into the review board system. These reforms will provide the guidance we consider necessary for public safety to come first. And let me make that point clear. Public safety must come first. Why are changes to the current regime of NCR accused by the proposed? Is there evidence that the system is not working? Mr. Speaker, recent high-profile cases, including in British Columbia, Manitoba, Quebec, Nova Scotia, have caused Canadians to question whether or not the laws are strong or clear enough to ensure that public safety is given paramount consideration in decision-making. Stakeholders, including victims, provincial and territorial ministers responsible for justice and public safety, and concerned Canadians have urged the government to take action that would ensure the safety of the public is paramount in consideration of decision-making process regarding NCR accused persons and enhance the role of the victims in the process. The responsibility of the ongoing monitoring of NCR accused persons rests with the provincial established review boards. If this bill passes, will it prevent people like Guy Turncott, Vince Lee, Alan Schornborn, and Andra Denny from being released into the community? This proposed legislation will provide important new tools to deal with high-risk NCR accused and ensure that the concerns of the victims are heard. It would not be appropriate to comment on specific cases, of course. What were some of the concerns raised by victims? And this is important because victims should be considered. Victims were concerned that their safety was not being specifically taken into consideration by review boards when they made dispositions. Victims also expressed concerns that they often had no way of knowing if and when an NCR accused was going to be given access to the community and were afraid that they would unexpectedly run into them without being adequately prepared. Wouldn't that be a shock? You walk down the street and all of a sudden you see a person that actually did harm to a family member or a colleague or a friend and not know about it. I don't think that's acceptable, and I don't think constituents accept that. Another reason why this bill is moving forward. If there was some of the concern, what are some of the concerns raised by victims? Or how does the bill respond to the concerns raised by victims, I should say? The bill will enhance the safety of victims and provide an opportunity for greater involvement of the victims in the criminal code's mental disorder regime. The legislation will help ensure that the victims are notified upon request when an NCR accused is discharged, allow a non-communications order between an NCR accused and the victim, and ensure that the safety of the victims will be considered when decisions are being made about an NCR accused person. What are the concerns raised by provinces and territories? Some provinces and territories expressed concerns that public safety was not being adequately taken into consideration by review boards when determining which disposition to order for a mentally disordered accused. How will the new legislation address the concerns raised by these provinces and territories? Addressing concerns raised by victims, provinces, and territories, the proposed legislation will clarify that the safety of the victims must specifically be considered, and the public safety must always be paramount consideration in the review of the decisions. Mr. Speaker, there's lots of questions and there's lots of good answers. That's why it's a good idea to get this bill to the next stage, to move it forward onto committee. I notice the NDP have some questions, but I look forward to their participation in the committee work. And I see this bill, this piece of legislation, actually achieving the needs that constituents have asked this government to do. And that's making sure that victims are understood and their rights are protected in these situations. Thank you, Mr. Speaker.
Questions and comments? L'honorable député d'Hochelaga.
Honourable Member from Hochelaga. Thank you, Mr. Speaker. The Honourable Member was saying that he was looking forward to working in committee. I presume that he's a committee member. I didn't quite get that, but I was wondering if the Conservatives were planning on listening to the witnesses this time, because most of the time at committee, what the testimony is interpreted by them. So do they truly plan to listen to the advice of specialists, for example, mental health experts, as well as make use of the recommendations they receive from them?
Well, Mr. Speaker, you know, that's one thing that we always do. We always listen to all the witnesses and we evaluate what they say and how they participate in the committee work. You know, I look forward to seeing them work with all sides of the House to bring forward the best piece of legislation forward. But keep in mind, this legislation, as it was being drafted, talked to a lot of people. They addressed and talked with a lot of victims. They talked to specialists in this field. So I think you're going to find a lot of witnesses that will come forward to committee will actually back this piece of legislation and say that we've actually been very close or been very good in bringing forward what is required for them to do their jobs.
Questions and comments? The Honourable Member for Kootenay-Columbia.
Thank you, Mr. Speaker, and I thank my colleague for his excellent speech. With regards to NCR, there's the NDP has been speaking all night specifically on criminal issues and how we're going to try and deal with those that are within the criminal system. What my question to my colleague is the proposed reforms extend the annual review to 3 years with regards to NCR, and I wonder if he could talk about that a bit.
The Honourable Member for Prince Albert.
You know, thank the member for his question. I appreciate all the hard work he's done on this file. I know he's put a lot of time and effort, and it's something that he's taking very, very seriously, and I appreciate that. The question's a good question. What it does is it changes the review period from necessarily an annual review to a 3-year review. This is a situation where the accused don't have to go through this review every year. Instead of having to look at the possibility of this person coming up for review and release and go through the process of being a victim and testifying in this type of situation, instead of being done every year, it'll only be now once every 3 years. That provides a little bit more stability for that victim and the family of the victim to actually proceed with their lives and move on and get this type of horrible situation behind them.
Questions and comments? L'Honorable Député de Montmorency-Charlevoix.
Honourable Member from Montmorency-Charlevoix. Thank you, Mr. Speaker. I will try to ask my question in the most simple terms to be certain that the member will not move on to another subject. Such a bill entails cost. Who will pay the bill? Thank you.
Well, I thank the member for his questions. I guess there's lots of questions that need to be answered. There's costs involved. But, you know, there's also costs in being a victim. There's costs involved in having a family member put into this type of situation and trying to recover that. There's lots of costs that need to be considered, and appropriate governments will take their role in paying for the costs accordingly.
Questions and comments? The honourable member for Surrey North.
Thank you, Mr. Speaker. Mr. Speaker, I'm going to actually ask the same question again. The member pointed out that there's governments that will bear this cost, and what we've heard from the Justice Committee, a Justice official, is that the costs will be paid by the provinces. Would the member agree that, have they discussed this with the provinces, in particular in regards to costs being downloaded to the provinces?
The honourable member for Prince Albert.
Well, it was actually the provinces that asked us to do this for protecting society. I'd like to remind their members we've invested close to $376 million in mental health research and continuing work for the provinces. We'll continue to do that as it's required. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Newton North Delta.
Thank you, Mr. Speaker. I rise tonight to speak in support of Bill C54, an act to amend the Criminal Code and the National Defence Act, mental disorder. We are supporting it at the current stage, sending it off to committee. And as a number of people have said before me, there are some serious flaws with the bill that we do want to address there. And we really do hope, because I've heard some very welcoming comments from across the aisle, that people are looking forward to the amendments we will take, and that they really want to work with the opposition in order to make a piece of legislation work. So with that in mind, I am sure that the NDP representatives on that committee will put their heart and soul into writing those amendments and hoping that that actually occurs, though it will be the first since I've been in the House. Anyway, Mr. Speaker, we all realize, and I don't think there is anybody in this room that would disagree, that public safety is paramount. It is one thing that whenever you go, no matter which part of the country you go to, whether people have children or they don't have children, they really care about their communities and making sure their communities are safe. Another thing that I have very, very strong feelings about is also the very poor job we are doing as a country, and a very poor job that the provinces are doing in addressing mental health issues. Recently, reports that have come out show that depression is on the increase, and the economic costs and the healthcare costs related to that are huge. And I know, for example, in my province of British Columbia, we saw many institutions that used to house people with mental disabilities, disorders, and those were shut down. So where did those people go? Guess what? They ended up out on the streets and getting into all kinds of trouble simply because they are ill and not able to manage on their own. But in this piece of legislation, we're not talking about that larger group. What we're talking about specifically is a very, very tiny group, a very small percentage of those with mental disorders who commit serious violent crimes. And I really think that that's the crux of this legislation, that this legislation is not for any crime committed by a person with a mental disability or a mental disorder, but we are talking about a group that commit serious violent crimes. And what this piece of legislation does, because as many of us are aware right now, based on a psychiatric report, even those who commit serious violent crimes can be released. And we have examples of that. I've got example of that in my riding, where I have a mother who comes to see me quite regularly because she just cannot understand how that can happen. But what we're talking about, as I said, are those who commit serious violent crimes. And now there is going to be an added step. So they will go before a review board. And now the victims will actually have a right to go to the review board and make impact statements. Look, Mr. Speaker, not everybody can do that. Not every victim is going to be able to feel those who perpetrated the crime. Not every person is going to be able to go and face the person who did them harm, directly or indirectly. But I think it's a very, very important part of the healing process and also the social justice process for that person to be able to go and say, this is the impact it has had on me. And I think that actually is a welcome piece of this legislation. And of course, now when the Psychiatric Review Board makes a decision, it's now going to be reviewed by the courts before a person is released. And that is an additional element to ensure public safety and to keep our communities safe. And you know, Mr. Speaker, when I look at that, that seems like a very, very reasonable thing that we would want to do. That before we release somebody, that we would actually want to have that reviewed. So that, yes, the medical profession, the psychiatrists are having their input. A review board takes place. At that time, impact statements are made, but that the courts then, just as a measure to ensure that things have gone on track, does get to review before the person is released. And all of that sounds really good. And then we really get to the crux of the matter. Who is going to pay for this? And if this is even more downloading of costs to the provinces, then I would have some serious, serious concerns. Because what happens is we've had so much of the downloading of the costs to the provinces, so much that they've had to pick up. And you know where that ends up in each province. I can tell you in British Columbia, it has led to impacting the education system, the healthcare system, and many other programs. So we want to make sure that we look at that, but also, as I mentioned earlier on in my speech, having been a high school teacher and a counsellor in a high school and counselled in the community as well, one of the things that really hits me hard is that I absolutely believe in our judicial system, which is a rehabilitative system, but I also absolutely believe in prevention programs, taking steps proactively. And I think that it's high time that we sat down federally and provincially and the parties work together to find ways to address mental health issues and also the cost associated with that. Now, some people are going to say, well, we can't afford to do that. But let me tell you, Mr. Speaker, that the cost of incarceration is eightfold to what the cost of quality education is. And yet, it seems that in many cases, we're not willing to spend $8,000 a year on educating a child. But we are willing to spend $60,000, $70,000, $80,000, $90,000, $100,000 a year to incarcerate and keep people in prison. And, you know, if incarceration was a judgment about how safe we are as a society, we just have to look to the south of us, where the U.S. probably has a very, very high number of people in prisons. And it doesn't make their streets and communities any safer, I would say less so. So, Mr. Speaker, we're pleased to support this, send it to the committee where we will have amendments. And as I said, we're very, very pleased to see that for a very small percentage of people with mental disorders who commit violent crimes, that there will be the opportunity for victims to make statements, and also now built in will be a review by the courts for those people to be released. And Mr. Speaker, I know you're giving me the signal. It's time, oh, it's not quite midnight yet. We have a way to go yet. Thank you, Mr. Speaker.
As it is 11:22 p.m., pursuant to the order given today, it is my duty to put an end to deliberations and allow us to move to the second stage of reading in the House. Now before the House. This is the following question.
That Bill C54, an act to amend the Criminal Code and the National Defence Act, mental disorder, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Is it the pleasure of the House to adopt the motion? All those in favour will please say yea. All those opposed, please say nay. In my opinion, the yeas have it. Pursuant to an order made on Wednesday, May 22nd, 2013, the division stands deferred until Tuesday, May 28th, 2013, at the expiry of time provided for oral questions. Orders of the day.